Yes, webale kubanga okyaliko webale kubanga okyagoberera yonna gy'osinzira okubanga gy'otulabira ekyolaba kiri mu Parliament y'eggwanga erya Uganda wetwogerera essaawa eno yennyini ababaka ba Parliament bamaze okubanga batuuka era njagala okukakasa nti n'aba NUP bamaze okubeera nga batuuka gwatanaba kubanga osubscribinga kirira wansi awo olaba ekigambo subscribe kikwateko kwata kale ka notification abeere nga atatomisinga nsonga yonna tugenda kukuwa bino byonna ogenda kubanga obifuna buterevu okuva mu Parliament ku mukutu guno ogwa Red Zone Media. Sebambulidde Patrick nze ngenda okubeera emabigawo muzindaalo nze ngenda okubeerawo nga byonna mbikutuusaako kakati atukyatetenkanya wano kulaba nga ebyuma bitereera bulungi nnyo ensonga obeere ng'ozifunira ddala okuviira ddala mu Parliament obeere ng'ofuna ekigenda mu maaso nga bwe nakusuubizira nga bwe nakutegeezezza tolina nsonga yonna gy'ogenda kubeera ng'omiisinga kakati oba tonaba kuba ng'osubscribinga annyongera okukujjukiza annyongera okukutegeeza nti kirira wansi awo olaba ekigambo subscribe kikwateko kwata kade aka notification ako kakuyambako okubeera omu ku abo abasookera ddala okumanya buli we tunaaba tutaddeyo ababaka ba Parliament jjukira olunaku olwajjo bakkiriza era batudde mu kye tuyita caucus meeting ne bassa kimu nti bannange mu Parliament leka tubeereyo era nga bino byayogeddwa lead of opposition Honorable Joel Ssennyonyi mu caucus meeting ya opposition caucus meeting gye batuuzizza olunaku olwajjo era bino n'abitegeeza eggwanga nti tugenda kubanga gye tuli mbadde njogerako awo n'omubaka nkiikirira ayitibwa Honorable David Lukyamuzika era n'ankakasa bulungi nnyo nti bayingidde era gye bali nga tewaliwo njawulo oba wa NUP oba wa FDC oba wa NRM oba wa kibiina ki ababaka bonna wenjogerera abasinga ennamba esinga obungi bamaze okubeera nga batuuka era kino kijje wano ku mukutu ogwa Red Zone Media nange Sebambulidde Patrick nga bwe nnakutegeezezza nti tolina nsonga yonna gy'ogenda kumiisinga njagala kukakasa bukakasa nti buli kimu ekigenda okuva sayidi eyo ogenda kuba okifuna buterevu ku mukutu guno ngenda kukuweereza kasavu kanyama kubanga jjukira essaawa eno yennyini Edi Mutwe Yasini Machete sekitoliko Yasini abanyi gwe mmanyi nga Machete baleetebwa mu kooti olunaku olwaleero naye bino byonna bigenza okujja byonna bizze mu kadde keekamu olowooza kiki ekiri emabega wa bino byonna kakati gwagoberera kyokola kya mutawaana nnyo naddala gwazzeko mu comment section Kibanda Felix webale kubanga koli agambye katusabire ababaka bonna aba opposition babeere nga babeera successful mu ekyo kye bagenda okukola ono babise Kiwanuka Moses n'agamba oh Lord save Uganda Mike Emma n'agamba Katonda wa Uganda save us ono abaddaani bamuyise Luwanga Hassan Allah save Uganda bamuyise Malik Emma we pray for our leaders of ruling party and opposition in opposition to be united ndoza message yebwete webadde ono bamuyise Mwambu Francis n'agamba asaba ababaka ba opposition babeere nga ate wono bamuyisani ono Ragasta Uganda n'agamba wabula ngeze ndabe embwa ya NRM ngezunga nti eyagala kalulu message etuuse bulungi nnyo Bwambale ali live okuva South Africa webale kubanga ogoberera ina gyosinzira okubanga gyotulabira ali South Africa naye obatona bakubanga subscribinga nyongera okutegeeza nti kirira wansi awo olaba ekigambo subscribe ukikwateko kwata kade ka notification ako kakuyambira ddala okubeera omu ku abasooka okumanya buli wetubatadde n'obanga ate otambula Serugo Jona webale kubanga kwoli Prose Nachaze nawe webale kubanga kwoli obubaka bwo butuuse bulungi nnyo Muwonge Fairidu webale kubanga nawe kwoli bannange tugenda kubanga tukuwa ekigenda maaso mu Parliament newankubadde nga waliwo wano ebitataaganyemukko katono nnyo naye nga njagala okukakasa buli kimu ogenda kubanga okifuna muggulire lyensembe y'okubanga mbawa waggulu awo nkakasa mmwe abagoberera mubirabye bulungi nnyo ababaka ba NRM oba kye tuyita NRM Parliamentary Caucus basisinkanye mu State House endebe ne basisinkana General Yoweri Kaguta Museveni era batudde bulungi nnyo ne baba nga bamaze okuyisa bonga baba NRM bakkiririza wamu era bo bakakasa nti kino kyamaze dda kyawedde dda okubeera nga kiyita kubanga bamaze okubanga bakikakasa amawulire ago nga kuwadde era gwabaddeko nkakaso bitegedde bulungi nnyo oluvannyuma lw'amawulire ago kwe kukomawo mu Parliament mbeere nga ngenda maaso n'okubanga mbawa ate ekiri mu Parliament kakati nga bwe ngenda maaso n'okubawa nkugambye nkuweereza direct okuva mu Parliament eno gye bayita Red Zone Media tolina walala wojja kubiraba abamu ku babaka ba NUP bennaakalabako bebo bolaba mu kifaananyi awo abali wamu n'omukulu amanyiddwa nga Balamu Barugahara mu kafaananyi ako nkakasanga kalabika bulungi nnyo ampuliriza era agoberera omukutu gwa Red Zone Media Sebambulidde Patrick nga bulijjo mbeerangawo wano okulaba nga nkutuusaako kakati bino twasazeewo tugenda bikuweereza butereevu okuva mu Parliament nga nakamala okwogera n'omubaka ankiikirira Honorable David Ukyamuzika nankakasa nti ababaka bonna abasinga obungi batuuse ngenze maaso n'okukolako okunoonyereza okutonotono era n'enkizuula nti kituufu batuuse. Honorable Kabuye Frank mulabyeko mu Parliament, Honorable Nyeko Derrick nga bw'omulaba mulabyeko mu Parliament, Honorable Kayemba Solo mulabyeko mu Parliament. Nze nno ntuuse mu Parliament ng'ekyalina nkalu kuba nakugamba ffe nga Red Zone Media ffe kamera zaffe tezirina we zitaba. Ntuuseko mu Parliament y'eggwanga erya Uganda. Parliament eyo gwampuliriza ng'ekyali nkalu, ababaka abamu nga tebannatuuka era nasobodde n'okugiyingiramuko nga nkalu bwe kalukalu nga bw'okiwulira nga tennaba kubanga ate egendamu omubaka yenna. Era ekyo ne ŋŋamba abantu bange abagoberera omukutu ogwa Red Zone Media ekyo nina okukibalagako. Parliament nga bwebadde nga tebannaba kubanga batuula, kakati wetwogerera batandise okubeera nga bayingirawo mpola mpola. Ba ex officials nabo batandise okubanga batuuka. Kakati gwe weekuumire ku mukutu guno. By the way, njagala obbategeeza mmwe abampuliriza era mmwe abagoberera omukutu gwaffe, tulina emikutu mingi kwe tusinziira okubeera nga tubaweereza, era nja kwongera ogenda maaso n'okubanga nsaba mu subscribinge ku mikutu egyo. Era wano wengenda okusinziira okusaba gwe wenna agoberera ogende ku mukutu kangu pininge wano waggulu. Nebaza nnyo mwenna abamaze okusubscribinga ku channel eyo, channel zaffe zonna, ate ne mubanga mutambula naffe ebbanga lyonna, ate era mu ngeri y'emu ne neebaza mmwe mwenna ababeerawo ne mutuyamba ku nsonga ya kaddata mu ngeri emu oba endala, nammwe kyemukola kya mutawaana nnyo. Ate nina wano emikutu omulala gwe njagala okubanga ate mbatapingira pininge gundi eno wano mubeere nga musubscribinga ku channel eno kubanga eyo channel nayo sister channel yaffe era tubeerawo nawo nga tugikozesa okulaba nga ate egenda maaso. Njagala kubanga mpita ayita mu bubaka bwammwe bwe mutadde mu comment section, wabula ekyo ngenda kikola nga ate mumaze okunkakasa. Buli amala okusubscribinga ng'ojja wano ng'oŋŋamba nti nze mmaze okubanga ate nsubscribinga. Nja kubanga ate ngenda maaso n'okubanga ntegeeza abantu nti omukulu tuli naye buterevu ku mukutu ogwa Red Zone Media. Ono bamuyisaani tugenda bawa ekiva mu Parliament. Serugo John webali kubanga kwoli, President Nachaz webali kubanga ogoberera, bamuyise Muwonge Faridu webali kubanga nawe kwoli, ono bamuyise Adidas ariho n'agamba God save our MPs, bamuyise ani ono Sudi Mechanic webali kubanga ogoberera, Nakiwewa Jen webali kubanga nawe kwoli, message etuuse nnyo nkulabye webali kubanga kwoli, Sofia ali live okuba UAE United Arab Emirates gyasinzidde okubanga gyagoberera, ayagala kulaba kiki ekigenda maaso mu Parliament. Ababaka baatugambye bagenda kutulwanirira, katulinde ddala tulabe butya bwe bagenda okutulwanirira, kiki kye bagenda okubeera nga bakola okusobola okuteekawo embeera. Oyo Nyeko Derrick wuuyo omulaba awo mu katambi n'ababaka abalala njaba bakusomera gwe kyolina okukola kiri kimu kusubscribinga ku channel zino, kyolina okukola kiri kimu kugoberera mikutu gyaffe, ate n'oba ng'otambulira ddala bubaaya sana nnyo ensonga zibeere nga zitambulira ddala. Ono bamuyise Mulo ali Uganda webali kubanga ogoberera, ono bamuyisaani Baruku Lawrence webali kubanga nayo kwoliyo najyo sinzira okubanga gyotulabira. Ono Tusiime Habibu n'agamba Mukama tuyambe yamba Uganda yaffe, webali kubanga ogoberera. Tumusiime Habibu message etuuse bulungi. Okoth Sam n'agamba ali Tororo webali kubanga ogoberera naye ng'omaze okusubscribinga. Bannange bwe batonaba kubanga osubscribinga, kirira wansi awo olaba ekigambo subscribe, kikwateko, kwata kade ka notification, awo ojja kubeera omu ku abo abasookera ddala okumanya ate tubeere nga tutambula. Njagala kubeera nga ate ampita ayita mbubaka buno speed nga bwe tugenda mu maaso n'okulaba nga tukutuusaako byonna ebiva mu Parliament, kuba nkugambye njagala kuwa kasavu kanyama buli ekiva mu Parliament ogenda kuba okifunira wano. Tuli mu kuteekateeka byuma kulaba nga ensonga ate ozifuna nga bw'olina okubeera ng'ozifuna mu ngeri emu oba endala. Bw'oba tonaba kubanga osubscribinga kikole oleme kubaako nsonga yonna gy'osobola kubeera ng'omisinga eno gye bayita Red Zone Media. Bw'oba tonaba kubanga ogisubscribingako eno ze services ezimu ku ezo z'obadde ng'osubwa ebbanga lyonna. So kakati nja kukusaba osubscribinge tubeere nga tutambula. Ono bamuyisaani Mukasa Kakala webali kubanga kwoli message etuuse nnyo. Derrick Mukwata webali kubanga kwoli message etuuse bulungi nnyo. Mwebya Bosco webali kubanga nayo kwoli live from Itakaiboru webali kubanga kwoli oba ate ekyo kiri ludda wa Itakaiboru. Naye nga thank you so much okugoberera omukutu ogwa Red Zone Media. Ono bamise Habiba Kabenge n'agamba ffe kwe tuli tuwakanya ekya UPDF Ammendment Bill okulaba nga bill eyisibwa efuuke etteeka mwe bagenda okwagala okuyitira okutukwatakwata bwatyo bwagambye. Ono bamuyisaani Mulo Jonathan webali kubanga kwoli Namulondo Hamina webali kubanga nayo kwoli message etuuse bulungi nnyo. Gidudu Bob ogamba otya webali kubanga ogoberera wali wambulako nnyo Gidudu webali kubanga kwoli message etuuse bulungi nnyo bubaya sana nnyo mukutu baguyita Red Zone Media. Bw'oba tonaba kubanga osubscribinga kikole tubeere nga ate tutambula ffenna. Njagala kubanga ntegeeza gwe wenna atambula naffe nti kyokola kya mutawana nnyo. Tuli mu studios kubanga tutukutuusaako embeera nga bwetambula bwegenda maaso. No bamuyisani no bamuyise Mwanje Deo webale kubanga koli agamba nze nalonda wa NRM mwewuunya okutegeera kwe gwe lwaki walonda wa NRM. Bamuyise Nagga wa Christine n'agamba webale kubanga ogoberera agamba otya Lord gwasinga okumanya Katonda gwasinga okubeera ng'omanya. Bw'atyo bwategeezeza obubaka butuuse bulungi nnyo gwe ampuliriza. Kakati njagala kubanga mbawa butereevu ekiva mu parliament era nga bw'okirabaawo gwampuliriza. Ababaka batuuka omu ku omu wabula batuuka mu ngeri ya kimpowooze naye nga nze mmaze okonfaminga omubaka nkiikirira. Honorable David Uchamuzi Kalwanga atuuse bulungi nnyo. Ndi musajja w'ebusujju era nga gye nsinzira okuba nga nkuweereza. Atuuse bulungi nnyo era oluvannyuma lw'okutuuka n'antegeeza nti munnange omu ku balonzi bange nti ye ssebo namaze dda okubeera nga ntuuka era tugenda mu maaso n'okuba nga tubalwanirira. Kaakati awo nange ne ŋŋamba katulinde tulabe ababaka baffe engeri gye bagenda okubeera nga batulwaniriramu. Ono bamwise Nagga wa Christine webale kubanga ogoberera message etuuse bulungi nnyo. Awanye George webale kubanga koli message etuuse bulungi nnyo. Joram Tikizimbala webale kubanga nayo koli message etuuse bulungi nnyo. Ono bamwisani Ragasta Uganda webale kubanga nayo kwoli. Ono Mike Emma webale kubanga kwoli. Shivan Ashan Mukasa Musa Karakata webale kubanga kwoli. Mugoma Augustine n'agamba how are you Shivan abadde amubuuzaako. Nakayondo Ruth webale kubanga nawe ogoberera. Calvin Vianney webale kubanga kwoli message etuuse bulungi nnyo. Vidik May webale kubanga kwoli message etuuse bulungi nnyo. Olwamise Sheikh Abdunuru Mugerwa agambye yamaliriza okusubscribinga. Big up webale kubanga nayo kwoli message etuuse bulungi nnyo ate webale kusubscribinga. Ganti Ganati I'm following daddy keep it up webale kubanga nawe ogoberera kyokola kya mutawana nnyo. Ono bamuyise bati ali Ntebe Sheikh Abdunur ali side z'Entebe gyasinzira okubanga ate agoberera omukutu ogwa Red Zone Media. Bw'oba tonaba kubanga ogusubscribingako kirira wansawo. By the way anyongero bategeeza tuyina emikutu egy'enjawulo kwe tusinzira okubanga ate tuweereza. Omukutu ogwo oba channel eyo gyempiininze waggulu nkakasa ng'osobola ogirabaawo enjagala ogikyalireko nayo beere ng'ogisubscribingako kubanga nayo tutera okuyitirako sayidi eyo ne tuba nga ate tukutuusaako ensonga ez'enjawulo nga singa oba tonsanze wano oba osobolera ddala okunsanga ku mukutu ogwo yiyo ngipiininze waggulu awo eri Red Zone TV 20 gendayo nayo beere ng'ogisubscribingako. Tukuweereza butereevu ekiri mu parliament. Omubaka Honorable David Uchamuzi Kalwanga amaze okubeera nga nkakasa nti ye atuuse. Baabo batandise okubeera nga batuula ensonga egenda kubanga etambulira ddala bubaaya sana nnyo. Webale kubanga ogoberera webale kubanga okyaliko bw'oba tonaba kubanga osubscribinga kikole tubeere nga tutambula ffenna. Kyolaba kiri mu parliament y'eggwanga erya Uganda omuli ababaka ab'ekibiina ekya National Unity Platform abaasuubizza nga beegasse wamu n'ab'oludda oluvuganya bonna mu kye twayise opposition caucus meeting eyatudde ng'ekubirizibwa lead of opposition Honorable Joel Ssennyonyi. Bali mu parliament essaawa eno yennyini bali mugenda maaso n'okuba nga batukolera ekyo kye baatusuubizza. Baatugambye bagenda kutulwanirira, bagenda kutuyirawo omubiri, bagenda kututeerawo embeera okulaba nga balemesa etteeka lino oba bbiiru eno oba ebbago lino okubeera nga liyisibwa. Ebbago ki? Amabago gali abiri nga bwe nakugambye. Waliwo ebbago erya UPDF Ammendment Bill 2025 erigendereddwamu okulaba nga kkooti z'amagye zitandika okukkirizibwa okubeera nga zigenda maaso n'okuwozesa abantu ba bulijjo. Ompulira bulungi nnyo Derek Mukwata bali kubanga kwoli. Waliwo ebbago eddala erimanyiddwa nga Political Parties and Organizations Bill era 2025 era nalyo ligendereddwamu okulaba nga ebibiina by'ebyobufuzi tebiddamu kuweebwa buyambi bwonna singa binaaba tebyetaba mu kye tuyita iPod Interparty Organizations n'ebisigadde dialogue. Kati nga bagamba jukire mabegakaawo twakuwa amawulire era twakutegeeza nti His Excellency Robert Kyagulanyi Ssentamu n'ekibiina kya NUP baagaana bino era ye yategeeza nti oluvannyuma lw'okulaba nti iPod eno ebaddewo ebbanga lyonna naye tewali munnayuganda kyagifunyeemu ategeeza nti nze n'ekibiina kyenkulembera bino sijja kubibeeramu. Kati jjukira waliyo akasente akaweebwa ebibiina by'ebyobufuzi gavumenti ng'efacilitating ng'eyita mu kakiiko k'ebyokulonda Electoral Commission. Naye zino ssente nabagamba teziba nti General Kaguta Museveni akikola nti ayagala. Sente zino ziweebwa ebibiina bino kubanga ziri mu mateeka. Ebibiina bino biyambibweko okubeera nga biddukanya emirimu gyabyo. Kaakati omukulu General Kaguta Museveni ndowooza oluvannyuma lw'okulaba nti abasajja bano aba NUP bawaganyadde ate nga ssente obuyambi buno babufuna ne basalawo ne bagamba nti leka tukyuse etteeka lino kwegamba ekibiina ekinaaba tekikkiriza okubeera mu iPod era nga tekikkiriza okubeera mu mukago guli okumanyiddwa nga National Consultative Forum kibeere nga tekiddamu kuweebwa buyambi obwo. Kakati nga target ya kibiina kya National Unity Platform kakati ago ge gamu ku mabago agagenda okuba nga galeetebwa, naye era byonna bw'obitunuulira biringa ebitagetinga His Excellency Robert Kyagulanyi Ssentamu n'ekibiina kya NUP, kubanga kyekyagaano genda mu iPod ate bwe tutunuulira ku tteeka ly'amagye kumpi ba foot soldiers ab'ekibiina kya NUP omuli ab'ebyokwerinda bakuuma His Excellency Robert Kyagulanyi Ssentamu kumpi be bali mu kooti ey'amagye era be bagenze maaso ebbanga lyonna nga bawozesebwa mu General Court Martial ekulirwa mukulu amanyiddwa nga Freeman Mugabe. Kakati we twogerera agamabago abiri ge gagenda maaso nga galina ekigendererwa ekyokulaba nga gayisibwa olunaku olwaleero, era singa ganaayisibwa General Yoweri Kaguta Museveni ye step yokka enaabeesigaddeyo kugateekako mukono officially lifuuka etteeka. Ebyo nabikusomera ebiri mu mateeka gano era bw'obanga ogoberera nkakasa nga kyenjogerako osobola okubeera ng'okitegeera bulungi nnyo. Weebale kubanga okyagoberera, bw'oba tonaba kubanga osubscribinga akkirira wansi awo olaba ekigambo subscribe nga bulijjo wentera okugamba okwate kade aka notification ako kakuyambako okubeera omu ku abo abasookera ddala okumanya nga tutaddeyo. Bannange temunsudiya mu subscribinge, zino ze services ezimu ku ezo azemuzzenga mu miisinga gw'atannaba kubanga osubscribinga. So nja kusaba okikole bulungi nnyo tubeere nga tugenda maaso n'okubanga tutambula ku mukutu ogwa Redson Media. Nange Sebambulidde Patrick nze mbeera nga wano ebbanga lyonna okulaba nga mbikutuusaako. Kakati nga tukyagenda maaso n'obbikuwa mpuliriza bulungi nnyo. Ababaka ba Parliament nga batuuse bamaze okuba nga batuula ensonga zitandise okuba nga zikolebwako essaawa yonna. Jjukira nkugambye batusuubiza nti bagenda kutulwanirira. Ndi wano ogenda maaso n'okuwanga nkuwa kyonna ekigenda okuba nga kiva mu Parliament. Naawe njagala osinzire gy'osinziira ogende maaso n'okuba nga ogoberera. We tunaaviira wano tujja kuba tutegedde batulwaniridde oba babadde batulimba. Sheikh Abdul Nur webale kubanga kwoli Koire webale kubanga nayo kwoli message etuse bulungi nnyo. Webale they have switched off agambye atyo they have switched off Parliament camera and the journalists are not allowed to take pictures from the Parliament. Exactly ekyo wabadde okisuubira neffe tujja kugezaako ekisoboka okulaba nga tukikutuusaako. Gidudu Bob n'agamba greetings once more for Ugandans and more blessings especially people from Budadiri, East Mbale, Sironko, Zagazaga and Nambozo Ministry, Karamoja Affairs. Webale kubanga kwoli ono bamwise tuli abamazima agambye be bamanyi ffe wetuli nnyo okubanga tugoberera. Kimbugwe Angel ogamba otya emasanafu kulufula oyo mwana wa Redson Media buli wetudda wadda. Webale kubanga kwoli ab'okulufula bandabire bagambe tubaagala nnyo tubaagalira ddala, we salute them. Webale kubanga kwoli Kimbugwe Angel ate webale kubanga ogoberera omukutu ogwa Redson Media ebbanga lyonna. N'abalala mwenna mukole ekintu kyekimu naddala nga mumaze ate okubeera nga musubscribinga tubeerangawo wano okwebaza abantu baffe abatambula naffe. Kakati gwatannaba kubeera ng'otandika okutambula naffe nga tonaba kubanga osubscribinga saagala ate oleme kubanga ate okikola. Kirira wansi awo olaba ekigambo subscribe kikwateko, kwata kade aka notification kakuyambako okubeera omu ku abasooka okumanya ate ne tuba nga tutambula mu ngeri y'emu. Nja basaba mu subscribinge ku channel yaffe eyo gye maze okuba nga mpiininga waggulu awo. MJ Media webale kubanga nayo ogigoberera. MJ Media 369 mu bannaye mu subscribinge ne ku channel ezo tugenda maaso okuba nga tusinzireyo kuweereza. Bwambale webale kubanga nayo kwoli SP Hassani ogamba otya message naawe etuuse bulungi nnyo message nga nkambwemukko. Christine babiri webale kubanga nayo kwoli ate gyonna gyosize okubanga gyotulabira. Emi bya Bashayija nawe bale kubanga ogoberera. Bannange ekyo kyolaba kiri mu Parliament nkyayita mu bubaka bwammwe nga bwe tulinda embeera nga bwegenda okutandika. Nkyayita mu bubaka bwammwe nga bwe tulinda embeera nga bwegenda okubanga etandika wano ku Redson Media. Tolina kyogenda kubanga osubwa naddala gwamaze okusubscribinga gwatanna subscribinga simanyi kyolinda era simanyi kiki ate kyogezaako kubanga otegeeza. Kakati mu tteeka lino erireetebwa ebimu ku ebyo bye twakutegeeza wuliriza. Bw'oba omanyi nti mulina ow'amagye mu famire obanga gwe baawo w'amagye nga gw'oli mukazi, bw'obanga gw'oli musajja nga mukyala wo w'amagye obanga olina muganda wo w'amagye, ne bwe banaakukwata ng'obbye enkoko, ne bwe banaakukwata ng'omusango teguliiyo ojja kuba ovunaanibwa mu kooti y'amagye. Omusango gwonna oguneefaanaanyiriza aggravated robbery nga gwe wawulidde gwe baggudde ku Edi Mutwe n'abalala ojja kuba otwalibwa butereevu mu kooti y'amagye. Bingi nnyo ebyo sijja kubinnyonnyola naye kasooka nteyite mubaka bwamwe kubanga twabibanyonnyola dda. Olamise Hadija Nakibuuka webale kubanga kwoli agambye we need more prayers. Sebo mukulu Patrick big up webale kubanga kwoli. Sheikh Abdul Nur Mugerwa yonna gy'osinzira okubanga ate gy'otulabira. Muliro Godfrey am from Namisindwa getting you loud and clear webale kubanga gy'oli ab'e Namisindwa bandabire. Eyo tetuba mu Eastern Uganda, Namisindwa abantu abo tubagala nnyo ate tukimanyi batwagala nnyo. Jamil Jamal webale kubanga nayo ku oli message etuse bulungi nnyo. Fredrick Waswa ali Dubai, Sir Fredrick Sempijja atufuna asinzira Dubai webale kubanga ku oli. Ono bamuyita Wandeba Joshua ali Kenya jasinzira okubanga agoberera ebigenda maaso mu parliament y'eggwanga erya Uganda. Webale kubanga gyoli ate nga gyosinzira okwagala okumanya biki ebigenda maaso mu nsi yo. Tuwe tuli okubeera nga ate tubikutuusako byonna. Sigala ku mukutu gwa Red Zone Media. Ono bamuyisani ko Businje Emma webale kubanga ku oli. Ono bamuyise Kibanda Felix ali side ze Busia yasinzira okubanga agoberera bannanga be Busia mu batulabire nnyo tubaagala nnyo era tuli beetegefu wano okulaba nga tubatuusaako embeera nga bwegenda okuva mu parliament. Waliwo ekibadde kiguddewo wano nga ndowooza batandise naye abakyali mu kwegeyageyamu kanjira mpita ayita mu bubaka bammwe. Rogers Kombi webale kubanga naawe ogoberera tuli abamazima agamba mwagala babalwanirire batya nga balwanye emirundi gyonna kakati ebisigadde. Namuwa Andrew webale kubanga nayo kwoli message etuse bulungi nnyo. Bannaye mu subscribing njagala olabe nga bo subscribing era njagala tuve wano ngomaze okusubscribing mu ngeri yemu. Njagala ndabe nga mu subscribing ku channel ya Feri emanyiddwa nga eri Red Zone TV 20. Kakati bwoba tonna subscribing nja kuba nsobola okukiraba kubanga ogwo omukutu gwe gumu ku mikutu kwe tusinziira okugenda maaso n'okubanga tukuweereza ku mukutu muto naye twetaagako abantu nga 10 okulaba nga tutandika okuweereza ensonga ez'enjawulo ku mukutu baguyita Red Zone TV 20 yeeyo channel gyempiininze waggulu awo. Gendayo subscribing then okomewo wano tubeere nga tutambula obuvaka bwamwe bwenkyali mukuyitayitamu. Lwamuse Dizalibwa Ramo amu Ramadan from Iganga webale kubanga gyoliyo najyo sinzira okubanga gyotulabire Iganga. Message etuse bulungi nnyo. Bwambale webale kubanga kwoli bonkeddeko Ismail ali Kata naye ono bonkeddeko nga mulabi waffe wadda webale kubanga okyaliwo n'olwaleero. Speaker Anuna aliwa Sheikh Abdul message tetegerekese nayo sobola okuddamu nontegeeza. Azira Uganda straight from Mbarara webale kubanga kwoli. Gidudu protest vote starting today by our MPs. Kizito Michael webale kubanga nawe kwoli kyonna kyokola kya mutawana nnyo okubaako ku mukutu guno ogwa Red Zone Media ate ne tubanga tutambula. Hilda Uganda we need more prayers for our country. Ono amise Masudi Nawoya Huzaifa and Masudi Anakoloke Mbale kwetuli asinzide Mbale webale kubanga ogoberera. Matia Wambi okuva mu UAE naye gyali yasinzira. Haruna Ali muganange nga wambulako nnyo. Haruna Ali naye kansubire olikiriya nnyo kansubire ebintu bitambulira ddala bulungi nnyo bubaya sana nnyo webale kubanga naawe okyagoberera Haruna Ali n'abali side yawo bandabire. Nkanji muri CD webale kubanga nayo kwoli ali mubende gye basinzidde okubanga ate bagoberera. Tusingwire Johnson naga is not only Baganda to be victims but also we the Banyankole. These NRM fools have become disastrous to us. Tusingwire Johnson message etuse bulungi nnyo ate loud and clear. Serugo Dennis webale kubanga nayo kwoli najyo sinzira okubanga gyotulabira. Serunkuuma ono abamuganda wange owendiga webale kubanga kwoli Serunkuuma. Robert yona gyosinzira ate okubanga ogoberera omukutu gaggadde ogwa Red Zone Media ensonga egenda ddala maaso okubanga ate tugikutuusaako. Bwe batonaba kubanga osubscribinga kirira wansi awo kamala okulaba baba batandise. Bakyali mu kwegeyamu ndowooza officially tennaba kubanga eggulawo naye kati ffe tubeerangawo kubanga tukutuusaako update ekigenda maaso kyonna mu parliament n'obanga ate okifunira ddala. Kakati batonaba kubanga osubscribinga nyongera okujjukiza n'okutegeeza nti kirira wansi olaba ekigambo subscribe kikwateko nga bw'olaba nga bwe tutambula era nga bw'osubscribinga ensonga zino oleme kubeera nga ate ozimiisinga. Mwe abamaze okusubscribinga mbeebaza kyemukola kya mutawaana nnyo. Tugenda kukuwa butereevu emboozi yonna nga bwegenda okubanga etambula okuva mu parliament era tuli butereevu mu parliament. Umaru Kaziro webale kubanga nawe kwoli Autoparts Kaziro Autoparts Nabugabo Kampala awo ntera okuyitawo nja kunoonyaako Kaziro Autoparts Nabugabo Kampala. Hilda Uganda wanjidde nisobole kubanga kwoli ono bamuyise batya ali Japani Chirinaldi webale kubanga gyoli Japani yona gyosinzira oli mu kibuga kye Japani awo. Bamuyise Naigoni Hassan nawe webale kubanga ate ogoberera omukutu ogwa Red Zone Media. Waliwo wanangambye eteekawo enamba yiino. banene baza mwenna abatudduukirira mu mbeera ey'akaddata ono ansabye ennamba ndowooza ajja kutudduukirirayo ne kaddata tubeere nga ate tetuva ku mpewo ennamba yiyo ngipiininze ndowooza wenna agisome yinza obutavaayo bulungi naye kangipiininge yaŋŋambye teekawo ennamba tukufunire ku kaddata nja kuba nkeeyanziza nnyo nebaza mwenna bambi abatubeererawo ne mutuyambako mu nsonga ya kaddata ate ne tuba nga tutambula mu ngeri emu oba endala naddala mu abamaze okusubscribinga ate nga mutambula naffe ebbanga lyonna ono bamuyisaani Matiya wambi bali kubanga oli message ekyatuukidde ddala bulungi nnyo ono bamuyisaani ono Serugo we bali kubanga oli Serunkuma Robert Umaru Kizito we bali kubanga kwoli ni ono Naigoni Hassani message etuuse bulungi nagambye me Museveni and Muhoozi Uganda is not your property omumbejja Imak we bali kubanga naye kwoli bamuyise Immaculate from Saudi Arabia abe Saudi bangambire embagala nnyo ate be bali kubeerako Joramutik Zimbala time for change olamuse Emmanuel Osere ali Tororo jasinzira okubanga agoberera thank you so much for following Red Zone Media from Tororo n'abe Tororo bonna batulabire ate bagambe tubaagala nnyo bubaya sana nnyo ekyo kyolaba kye kigenda maaso mu parliament tebannaba kubeera nga batandika wabula ababaka bagenda batuuka mpola mpola ababaka benna akakonfirminga ko mbakugambye naye nja kuddiramu abamu ku bo bemaze okukakasa nti bamaze okubanga batuuka wetwogerera ng'oggyeko bali benkuwadde okuli Honorable Kabuye Patrick Frank Kabuye okuva e Kasanda kuliko Honorable Nyeko Deriki okuva e Makindye kuliko omukyalo ono yajjayo yani ono omukyala mwerabidde erinnya oyo Honorable oyo gwolaba ow'enviiri oyo emmyufu atuuse Honorable Nakimuli Heleni maze okumulabako Honorable Kalwanga David Luchamuzi maze okumulabako ng'atuuka sinnaba kulaba ku Honorable Zaake naye nga nkakasa naye ateeka okubanga yatuuse dda kati gwe amaze okubanga osubscribinga kyonna ekigenda maaso ogenda kubanga okifuna butereevu tolina nsonga yonna gy'ogenda kubanga omiisinga Lubega Moses bali kubanga gwoli agambye Gaborone Botswana yasinzidde Lubega Moses e Botswana yasinzira okubanga ate agoberera enkuto gwa Red Zone Media Kimenyi Deus agamba kwali buterevu nnyo Nakise Kamadina we bali kubanga nawe ogoberera Mirembe Rose ali saidize Dubai agamba we bali kuweereza waliwo wanantereddeko kaddata ka 15 naye tompadde erinnya lyo banaye naye yazza kaddata ka 15 naye tompadde erinnya lyo sikutegedde naye erinnya kansubire nja kulifuna wano nga bwe tugenda maaso n'okubanga tutambula Mirembe Rose bali kubanga kwoli Sheikh Abdul Nur agamba Sheikh Abdul Nur Mugerwa live in Entebbe wetuli nnyo Red Zone bannange mwebale kuweereza mwebale kuwagira mukutu gwa Red Zone bwati wabebaza Sheikh Abdul Nur abagamba mwebale kubeera ku Red Zone ate mwebale kubanga mugoberera ensonga nga bwe zitambula Christine Babirye n'agamba Red Zone Media webale kutuweereza era bannange tozikiza munnange webale kubanga naawe obeerangako ate naawe notazikiza Nakato Harriet webale kubanga kwoli asinzidde Nansana wano kumpimpi webale kubanga naawe ogoberera ekiri ku parliament kyekyo ate nga tugenda kukikuwa paka yebinaggwera Kiwanuka Moses webali kubanga kwoli Mary Broncon kadde kakumanya baalya milioni 10 akadde kakumanya ababaka abeegabira obukadde 10 oba abaafuna obukadde 10 ate mu parliament jukira gye buvuddeko awo naye by the way ensonga ngenda zikuwa bulungi nnyo ensonga ngenda kujja mbere nga nzikutuusaako ababaka ki abaalya ssente obukadde 10 Yes, tukyaliwo tubadde tutereezaamu wano tubadde tulaba nsonga nga bwe zitambula oba oliawo tuleme kugamba nti ate kiki ekigenda maaso mu parliament njagala kubanga nkuwa buli mbeera yonna nga wenaabeetambula bw'ogenda okubanga ogifuna okuvaako mu parliament y'eggwanga erya Uganda butereevu ekigenda okuva eyo ogenda kuba okifunira wano Gidudu n'agamba his NRM MPs knows why the stick has 2 ends abuuza abaka ba NRM bamanyi bulungi nnyo nti lwaki omuggo guyina ensonda 2 ababuuzizza message etuuse bulungi nnyo Elia Sabiti agambye nze ndi ku mulimu bro bidiko webali kubanga kwoli Nkuma Johnson ali side ze bombo jasizira okubanga gyatulabira webali kubanga nawe ogoberera ko businje Emina webali kubanga nayo kwoli it's ko businje Emina yonna gyosinzira okubanga gyotulabira ola message Geoffrey Godfrey wakwa Bui live from Saudi Arabia go bamwise Godfrey Magero today is today from Busia Kenya jasinzira okubanga jatulabira tulyahebwa Innocent nagamba aliyibanda protest vote abeyibanda agibategezeza bamwise tulyahebwa Innocent Sergo Dennis nagamba Emina Sap webale kubanga okyagoberera nawe Namuleme Mary time for change nawe message etuse bulungi nnyo oramwise Herbert loud and clear Herbert Saudi Arabia jasinzira okubanga ate agoberera River Flow I am Godfrey from Kenya. I want to know what happened in Uganda, in my parliament now. In Uganda, they are passing a bill called UPDF Amendment Bill, which aims to allow military court-martial, the general court-martial of the military, which was initially initially a disciplinary committee in the Uganda People's Defense Forces, but it's now aimed to be made a real court, like a general court martial, to be allowed to treat or to trial civilians. It is now going on in Parliament. And another bill called the Political Parties and Organizations Act. That's where the tension comes from. Webale kubanga okyagwera mukutu ogwa Red Zone Media ono bamuyise Serugo Dennis webale kubanga nayo kwoli Kobusinje Emina webale kubanga nayo kwoli ono bamuyise Katali I'm on bro big up webale kubanga okyagoberera Yasini Bossa from Kingston London yasinzira okubanga ate agoberera Yasini Bossa webale kubanga obeerako webale kubeera nga ate ogoberera omukutu guno ogwa Red Zone Media ensonga nga bwe zitambula ate ne tubanga tuzikutuusaako patulaba kubanga osubscribinga kikole obeera omu ku abasookera ddala okumanya buli tunabanga tutaddeyo obeere nga ate ogenda mu maaso n'okubeera ng'obeera notified naye nga mu ngeri y'emu ngenda kwebaza abatuyambako mu nsonga ya kaddata kuba mumanyi ebye Uganda si byangu nnyo ate naddala ng'ensonga ezigenda maaso n'okubanga zikuweebwa nazo si nnyangu ate kati baabo bali mu kuteekawo general court martial nange okuwa obuwe amawulire saawa yonna ojja kusanga ate nga giwunye kati webale kubanga okyagoberera nga tukyalina obusobozi obubikuweereza mwebale kubanga munyambyeko abanyambyeko mu kaddata waliwo yampaddeyo ddata ow'ettaano naye erinnya saalitegedde ono bamuyisani Nakato Harriet webale kubanga kwoli agambye am Harriet from Nansa webale kubanga ogoberera Nakato Harriet mukutu gwa Red Zone Media webale kubanga kwoli ate naddala ng'omaze okusubscribinga Nakiseka Madina time for change webale kubanga nawe ogoberera bamuyise Naigoni ali South Africa jasinzidde on live from Bombo Jonathan Nkuma Jonathan Chirumira Joseph webale kubanga nayo kwoli Wandeba Joshua webale kubanga nayo kwoli Dramatic Zimula onagamba Rongo government webale kubanga nayo kwoli Sekamate Kamada webale kubanga nawo ogoberera Nakiseka Madina wake up Ugandans message etuse ono bamwise Kizito Senteza nagamba nze Senteza Kizito kwetulinyo asinzidde kata webale kubanga ogoberera Sekamate Kamada nawagamba how are you doing we are doing good webale kubanga nayo kwoli Ken Kichengera nagamba kuwali nnyo Ayera Edron live from Kololo webale kubanga nayo kwoli Kobusinje Emina webale kubanga okyagoberera Enos Ayera webale kubanga nayo kwoli omamuse Kibanda Felix webale kubanga kwoli n'asaba abaka ba parliament nga to think wisely like people from Busia and Eastern Uganda at large Nabende Isaac agamba ye Nambeshe and other MPs from Bugisu region most especially Bududa district should refuse it totally. But the moment you make a mistake, we are waiting for you. Bamuyise Nabende Isaac message etuse bulungi nyagamba ababaka abava mu bitundu bya Eastern Uganda naddala Bugisu region nagamba okusingira ddala abava mu district ye Bududa bandi badde bayigina weringa ekintu kino naye we bakolera ensobi agamba tubalinze ate era tubalaba kakati fewe tuli okubeera nga ate tubikutuusaako sigala ku mukutu guno Red Zone Media naddala ng'omaze okubeera ng'osubscribinga ensonga obeere ng'ozifunira ddala bubaya sana nnyo oleme kubaako nsonga yonna gy'omiisinga nkugambye ekiri mu Parliament ababaka abasinga obungi bamaze dda okubeera nga batuuka abamu bakyatuuka we twogerera naye nga byonna ogenda kubeera nga ate obifunira ddala guno gwe mukutu ogutazikiza era ogutalekeraawo kubeera nga tukuweereza buli kimu nga bwe kiba kirina okubeera nga kitambula naddala gwe amaze okuba nga osubscribinga kyenjogerako okimanyi bulungi nnyo mu Parliament kugambye batuuka mu mbeera ya musoolesole batuuka abamu ne batuuka abalala ne bagira nga ate balindako abalala baleka bakyali ku zikantiini kati ffe weetuli byonna tugenda kuba nga tubikutuusako ngenda kukusomera wansi awo emirundi General Yoweri Kaguta Museveni gyazze nga manipulatinga Parliament y'eggwanga erya Uganda n'ayisaawo byatera okuba nga ayagala wabula Parliament nejjanga egamba bannayuganda nga bwegenda okubanga ebalwanirira naddala ababaka abali ku ludda oluvuganya naye nga byonna byayagala ebiri mu feva ye bizzenga biyita era bibadde nga biyitawo kakati ogenda kubifuna wano ku mukutu ogwa Red Zone Media. Nange Sebambulire Patrick nga nze ndiwo okubeera nga ate mbikutuusaako. Ono bamuyise Kisekka Ronald ali Japan we bali kubanga ogoberera, bamuyise Bill Gates Kitumbwe kya mulongo kwe tuli nnyo naye twongere okusabira Uganda. Cedric Kefa, remove the coverage of your camera sebo. Sitegede kyategeeza. Anna Kisekka Madina bali kubanga nawe kwoli. Ono bamuyise Daya Ibrahim bali kubanga nawe kwoli. Ali Kaliro district side zeyo mu Eastern Uganda bali kubanga nawe kwoli. Kintu Andrew Namagambe Bettina Amini Kenya we bali kubanga nawe kwoli. Shadia Nalukwago live from Turkey we bali kubanga kwoli. Bamuyise Talemwa Uganda should not be buried please live in Bulisa. Sheikh Abdul Naga Ugandans mwebase abasajja batumalawo wake up please message etuse bulungi nnyo. Naigoni Hassan nawe bali kubanga kwoli. Fredrick Waswa bali kubanga nawe kwoli nnyo. Ntege Peter nawe bali kubanga kwoli. Naga NRM hands the rope to its MPs. Justin available to see what's going on kwali bamwisa Justin. Magoya woman let us also do whatever it takes we bali kubanga nawe ogoberera. Ono bamwisani Honorable Councillor Alamanzani Muwanga we bali kubanga ogoberera message etuse bulungi nnyo amukutu gwa Red Zone Media. Mbazira Samuel live from Kiboga NUP Kontiko protest vote bati bagambe Katongole Frank n'agamba bw'aba ssente z'okuyisa etteeka eryo bwe bagaana babakube. Kato Naboth n'agamba NRM Eddie Mutwe is live we bali kubanga kwoli. Morning Eddie Mutwe is live. James Agre na Bongo Moyinda I'm live from Busoga. Ono bamuse Opio Bone tugwawo we bali kubanga nawe ogobera message etuse. Ken Chengera we bali kubanga nawe kwoli message yo etuse bulungi nnyo. Ono bamuyise Nansamba Florence agamba mulekeraawo oba wakanya bakole ebye bakole bagalo bakyategeeza. Ganti we bali kubanga kwoli message etuse. Mayor Ricky Sakibu we bali kubanga kwoli message etuse. Ayera Edron we bali kuba ali Kololo we bali kubanga ogoberera message etuse nnyo. Jeramatic Zimbala agamba kitalo nnyo ekya NRM. Nakato Harriet we bali kubanga kwoli. Na Kisekka Madina we bali kubanga kwoli. Nyombi Francis we bali kubanga ogoberera message etuse. Dekeri ali Hoima we bali kubanga ogoberera. Kizito Senteza we bali kubanga nayo kwoli. Godfrey Magero nawe bali kubanga ogoberera. Jedda we bali kubanga kwoli. Ono bamuyise James Agre na Bongo Moyinda ali side ze Busoga we bali kubanga kwoli. Atyo ono Sheikh Abdul we bali kubanga okyaliko. Na Kisekka Madina we bali kubanga nayo kwoli. Ongodi ya George we bali kubanga nawe ogoberera. Obubaka obulala buliwa. Mukibi Ivan we bali kubanga kwoli. Tukyagenda maaso n'okubanga tukutusako ekiva mu parliament. Embeera ekyali ya kimpowooze. Ababaka batuuka tebatuuka, batuuka bafuluma, batuuka tebyategerekeka. Sinnamanya kisembayo naye nga ndi wano okubanga nkikutuusaako kyonna ekigenda okubanga kivaayo. Wuliriza. House is now processing the political parties and organizations amendment bill. Ompuliriza bulungi nnyo. Etteeka erisoose baganye kamera munda yaabwe bagijjeeko. Etteeka erisoose lyebasoosezza ku mmeeza bali mu kuli processinga. Etteeka ery'ebibiina by'ebyobufuzi erigenda okukaka ebibiina byonna okubeera nga bituula mu mukago gwa iPod. Bwe nakugambyeko era embeera ebeere nga yampaka. Galabuzi Yasini angaye Patrick ngantidde totya. Talemwa naga they are delaying. Ono bamuse Harriet Nachiwa we bali kubanga nayo kwoli. Mukibi Ivan we bali kubanga nayo kwoli. Command we bali kwa Lydia Naigaga we bali kubanga kwoli. Bwambale Jovenile we bali kubanga nayo kwoli. Bagaga Robert we bali kubanga kwoli. Isa abide Sadiki ugamba we bali kubanga kwoli message etuse bulungi nnyo. Namuli Sylvia ali side za United States of America we bali kubanga kwoli. United States of Kamwocha jasizidde we bali kubanga ogoberera. Bannange ekigenda maaso era ekiriwo bali mu kuprocessinga etteeka liri erisooka. Waliwo nno wanankubira simanyi lwaki ankubira. Agambe Mulindwa Julius live from Kigali webale kutuweereza munange naawe webale kubeerako. Ekyo nakyokola kya mutawaana nnyo. Kakati tonkubira simu kubanga simanyi lwaki oba onkubira naye at least message yo emaze okubanga etuuka bulungi nnyo. Kakati njagala obategeeza nti ekigenda maaso ssaawa zino zennyini mu parliament bamaze okubanga batebolinga era bali mu kuprocessinga essaawa yonna etteeka liri lye basoose nalyo. Kyesimanyi kino bakidireyinze kigenda kujja kiki ekigenda mu maaso wabula kati kyengezaako kutegeeza mu parliament essaawa zino zennyini abasajja bali mu kukola kaweefube era bali mu kuprocessinga essaawa eno wompulirira era kyolaba kyekiri mu parliament bali mu kuprocessinga Political Parties and Organizations Amendment Bill 2025 sponsored by Honorable Nakuth Faith Loru Chuna omubaka mu parliament akiikira district y'e Napak ng'omubaka omukyala era nga ye treasurer ew'ekibiina kya owa NRM Parliamentary Caucus ono professional accountant lecturer muzadde alina abaana basatu era mukyala mufumbo akiikirira district bagiyita Napak esangibwa mu bitundu ebyeyo mu Northern Uganda. Omukyala oyo yagenda okutebolinga biiru eno gye batandise nayo kakati gwampuliriza eno gye bayita Red Zone Media. Tewali kyogenda kubeera ng'omiisinga waliwo ngambye nga tomutulaze kamukulage oyinza okulowooza nti nkuweereza butereevu okuva mu parliament era kyofuna kiva butereevu mu parliament y'eggwanga erya Uganda. Omukyala ono ye mubaka agenda okutebolinga era bali mu kuprocessinga essaawa eno yennyini gwampuliriza basoose n'etteeka eryo erimanyiddwa nga Political Parties and Organizations Act. Omukyalo ono gwe nkugambye bamuyita Nakuth Faith Loru Chuna mubaka akiikirira Napaka district ng'omubaka omukyala ye treasurer owa NRM Parliamentary Caucus professional accountant mukyala yasoma ebitabo bye ate nga sa accountant kyokka lecturer asomesa ku university ezimu professional accountant nga bwe nkugambye ate nga muzadde alina abaana basatu era mu bino byali mu kuleeta mu mativu nti abaana be abasatu be yakazaala agenda kuba mu mativu nti abaana be bajja kunyumira Uganda egenda okubeeramu ebyo byali mu kuyisa. Mukyala mufumbo ate nga agamba 100% nti munna Uganda. Wuliriza bulungi nnyo omanyi bino ebintu Joel Ssenyonya abyogerako ate buli wabayogera mu parliament kamera baziggyeko naye njagala obeereko buli kimu ogenda kubeera ng'okifuna era ngenda kukikuwa butereevu. Wulira wano we baŋŋambye ngenda kulipotingira ekiva mu parliament butereevu naddala ng'omaze okusubscribinga. Oba tonna subscribinga kikole nga bukyali oleme kubaako ky'omiisinga. Wulira wano we baŋŋambye kugambye nkuweereza kuva mu parliament butereevu. Eno bagiyita Red Zone Media bampita Sebambulidde Patrick. Bagamba Leader of Opposition Honorable Joel Ssenyonya says the Committees on Legal and Parliamentary Affairs and Defence and Internal Affairs processed the Uganda People's Defence Forces Bill 2025 too quickly for his liking. Ssenyonya agamba era nga bwe yayogera ne Luli awakanyizza sipiidi ey'ekika ekyawaggulu obukiiko buno obubiri gye bwakozesa nga baprocessinga nga beetegereza n'okwekenneenya amabago gano abiri naddala ebbago lino erya UPDF Ammendment Bill erigenda mu maaso n'okuba nga lireetebwa. Wabula nkugambye batandise n'eriri kati Leader of Opposition abaako n'ensonga za nnyonnyola ez'enjawulo. Kugambye nkuweereza butereevu kuva mu parliament era ne nkugamba eno bagiyita Red Zone Media era ne nkutegeeza nti bw'oba tonna subscribinga ojja kusubwa bingi nnyo. Kaakati genda mu maaso ng'okkirira wansi awo olaba ekigambo subscribe kikwateko kwata akade aka notification akakade kakuyambako okubeera omu ku abo abasookera ddala okubeera nga bamanya ate ne tuba nga tutambula ffenna. Era mu mawulire ge tulinawo nago nga njagala okugakuwa Edi Mutwe Edward Rogers Sebuufu amaze okuba nga atuuka mu kooti ayo side nayo ndi mu kuwaayo kubanga eno gye bayita Red Zone Media buli kimu nnina okuba nga nkikuwaako gwe munnayuganda agoberera obeere ng'ensonga zino zonna ogenda mu maaso n'okubeera ng'ozitegeera. Saagala kubaako nsonga gyendeka mabega. Guno twagwewa tulina okubeera nga tukuweereza side zonna tulina okuba nga tukuwa ekyo kye weetaaga okuba ng'omanya. Mu mawulire agakagwawo Edi Mutwe Edward Rogers Sebuufu n'abamu ku ba political prisoners ab'enjawulo bamaze okuba nga baleetebwa nga bwengenda maaso n'okuwa ekiri mu parliament n'eyo njagga kutegeeza obeere ng'ogenda maaso okubeera ng'ogategeera bulungi nnyo. Edi Mutwe amaze okuba nga aleetebwa mu kooti y'e Masaka agende maaso n'okuba nga ate emisango giwozesebwa. Kakati ako kategedde bulungi nnyo. Simanyi kyabadde kigendererwa ki okulaba nga bino ebintu bibeerawo ku lunaku lwe lumu. Eno Edi Mutwe bamuleeta mu kooti ate eri parliament eri mu kuyisa amateeka gali kye sinnategeera gwe munnayuganda mpuliriza ojja kgenda mu comment section osanga onambuulira oba oli awo wandibanga gwe olina kyojja okulowooza oba okutegeera ku nsonga eziri awo ekiyinza okuba nga kisusse ku nze. Kakati nga tuzeeyo mu parliament nakugambe ngenda kuwa kasavu kanyama sigala ku mukutu guno naddala gwe amaze okubeera ng'osubscribinga naawe atanaba okuba ng'osubscribinga kikole tubeere nga tutambula ffenna. Wuliriza Speaker Nalongo Anita Amonga akubiriza Parliament asks Prime Minister Robin Nabbanja to present a report on the priority of Adonia Ayebare's alleged appointment to cabinet. Bino byonna biri mu parliament. MP Jonathan Odul challenges the appointment. Bano nno batandise na bino ebyoku appointing Adonia Ayebare n'ebirala bifaanana bwe bityo. Leader of opposition waliwo ngambye njagala kulaba leader of opposition bwafaananye. Honorable Mukasa Alozias akiikira abantu ba Lubaga South yatuuse dda mu parliament wali bulungi nnyo era ogenda kubanga ensonga ozirabira ddala naddala gwe amaze okubeera ng'osubscribinga obukiiko buno obumazidde butuula ne buyita mu bbago lino nabwo ngenda bikuleetera nkuleetera obukiiko obwo butuulako baani abaliko eno gye bayita Red Zone Media. Joel Ssenyonyi bw'ati bw'alabise era awakanyizza nnyo ne sekuwakanya yenna era n'avumirira obukiiko speed gye bwakozesa okugenda mu maaso n'okubanga bayita mu mabago gali nga bwe nkugambye. Njagala kubanga nkuwa wano amanyi nakugambye buli muntu agoberera omukutu guno tabaako nsonga yonna gy'amisinga. Buli kintu obeera okifuna bulambalamba. Buli kintu obeera okifuna bulambalamba. Bwe nfuna Agakagwawo mu ddakiika eyo yennyini mba nnina okujja ate ne mbanga nga kutuusaako n'oba ng'ogenda mu maaso n'okubeera ng'ogamanya. Leader of opposition Honorable Joel Ssenyonyi uliriza. Joel Ssenyonyi awakanyizza era n'agamba committees on legal and parliamentary affairs and defense and internal affairs committees process the Uganda People's Defence Forces Amendment Bill 2025 too quickly. Agamba nti bano lwaki bakozeseza speed y'ekika ekyawaggulu okulaba nga bayisa egundi eno, lwaki bakozeseza speed y'ekika ekyawaggulu okulaba nga bayisa bino, era n'agamba takkiriziganya nakyo. Wulira we bamuzeemu okusinziira ku bamu ku babaka aba parliament naddala ab'ekibiina kya NRM kubankuga nakugambye bo munnange bino bibakolera era bamativu n'ebyo ebigenda mu maaso okubeera nga bibaawo. Wuliriza okuva mu parliament. But MPs Stephen Bakka Mugabi, who chairs the Committee on Legal and Parliamentary Affairs Committee, says the rules of procedure permits processing of bills within 45 days. Naye bo batutte ennaku mmeka? Ono bamuyita Bakka Stephen Mugabi akiikirira Bukooli County North. Simanyi oba nsobola okuwa ekifaananyi kye wano nemba nga siruddeewo kubanga nga bw'obimanyi nina okubanga nkuwaggulire ku ggulire, nina okubanga nkuwa update ku update ekiva mu parliament kubanga olina okugenda maaso n'okubanga okitegeera ate nga guno twagwewa. Tulina okugenda maaso n'okubanga tuku updatinga, tulina okugenda maaso n'okubanga tukutuusaako embeera yonna nga bw'eba etambudde. Omubaka avuddeyo n'ategeeza Joel Ssenyonyi. Wuliriza kifaananyi nja kikuwa oluvannyuma. Tuli mu parliament, ensonga zigenda maaso n'okubanga ziteesebwako. Stephen Bakka Mugabi ono nga ye chairperson owakamu ku bukiiko Ssenyonyi bw'ayogeddeko, akakiiko akamanyiddwa nga Legal and Parliamentary Affairs Committee. Akakiiko kano ke kamu ku obukiiko bwe bawadde ebbago lino ne baba nga baaliyiseeyiseemu. Kati omukulu oyo ategeezezza nti gwe Ssenyonyi by'oyogerako newankubadde tukimanyi bulungi nnyo nti kale twapapye, wabula ssemateeka atukkiriza okubeera nga tuprocessing oba nga tuyita mu nsonga eno okumala ennaku 45. Kakati gwampuliriza ennaku 45 ziweze oba tezinnawera. Bo bakozeseza ennaku mmeka? Kakati eyo yembeera egenda mu maaso. Tukyali mu parliament, embeera ekyagenda mu maaso n'okubeera nga yakimpowooze. Robin Nabbanja azze abeere nga ateekawo kye bayita rules of procedure ku nsonga eza parliament. He demands an explanation from the Prime Minister. Empeera bwekyo bwekyali mugenda maaso n'okuba nga etambula ensonga ebeere nga ate etuuka bali mu kuprocessinga bino nga bwebigenda mu maaso. Bali mu kuprocessing kakati atawulira ogagana Agakagwawo bannange eno gye bayita Red Zone Media. Togenda kubanga ate omisinga ensonga yonna naddala ng'omaze okusubscribinga. Bw'oba tonna subscribinga kikole bannange. Waliwo wanansindikiddeyo ka data anteereddeko ka data ka 13 bannange. Weebale message etuuse, weebale kyonna kyokoze kya mutawana nnyo, erinnya talimpadde. Yangambye ka data ka 3. Shipments from the Committees on Legal and Parliamentary Affairs report on Honorable Faith Achul plenary. Bannange bino munzikirize mbibasomere. Tugenda mu maaso mu parliament. Ensonga zimaze okuba nga zikonfamingibwa. Nina ekiwandiiko wano kye nnaakafuna kati wenjogerera. Abasajja bakitaddeko emikono. Emikono gyalumye dda ku kiwandiiko kye njagala okubanga nkusomera eno gye bayita Red Zone Media. Bwe watonaba kubanga osubscribinga nyongera okutegeeza nti kirira wansi awo olaba ekigambo subscribe kikole obeere nga ate ogenda mu maaso n'okubanga otambula naffe. Bino byonna tolina walala ojja kubijja okujjako wano ku mukuto gwa Red Zone Media. Nange Sebambulidde Patrick nga nze ndiwo okubeera nga ate gwe muganange mbikutuusaako yonna gy'osinzire okubanga gy'otulabira era gye njagala osinzire ogenda mu maaso n'okubanga ate ogoberera ekigenda mu maaso mu parliament y'eggwanga lyo. message nja kuziddira PRA command nja kuziddira oberenga ate ofuna byonna ebinaba biva side eyo wano nga bangamba nti ebimu ku ebyo general analysis, observation, findings and recommendations. Ompuliriza bulungi nnyo okuva mu kakiiko akamanyiddwa nga Legal and Parliamentary Affairs Committee baleese bamaze okupresentinga kyetuyita analysis, observation, findings and recommendations. Ku tteeka liri akakiiko kano nakugambye katuulako abamu ku babaka ab'enjawulo era ababaka abo bamaze okubanga batuula ne baba nga bayitaayita mu nsonga zino kakati ensonga ezo bazireese bye bazudde bye bayiseeyiseemu ne bye bategedde nti butya bwe birina okubanga bitambula kati babireese essaawa ya kubipulizentinga. Omukutu baguyita Red Zone Media gwamaze okusubscribinga bino byonna ogenda bimanya atanaba kubanga osubscribinga sore oyinza okubaako byomisinga gye bujjako kubanga ne tunaba tuvudde ku live tulina okugenda maaso n'okubeera nga tukutuusaako embeera yonna nga bw'enaagenda maaso n'okubanga etambula. Nina baganda bange abali mu nsonga za Edi Mutwe era nabo updates bajja kuzikuwa era bwe bazimpa wano nazo mba nina okugenda maaso n'okubanga nzibatuusaako. Sirina kye sigenda kubawa gwe sigala wano naddala ng'omaze okubeera ng'osubscribinga buli kimu ogenda genda maaso n'okubanga ate okifuna. Kakati wuliriza bulungi nnyo wano nga bagamba the part of the analysis examines the bill and considers the provisions being amended, the proposed amendments made to the provision, the effect of the amendments including the provisions legality, effect and effectiveness in light of other provisions of any other law, existing public policy if any, court decisions and the mischief it intends to cure. The analysis is classified in thematic areas the bill proposes to amend, after which a recommendation is stated. Mukutu baguyita Red Zone Media webale kubanga okyagoberera naddala gwe amaze okubeera ng'osubscribinga bwota naba kubanga osubscribinga kikole okkirira bukkirizi wansi awo olaba ekigambo subscribe n'okikwatako okwata kade aka notification kakuyambako okubeera omu ku abo abasookera ddala okumanya buli wetuba tutaddeyo ate n'obanga otambula naffe. Njagala kubanga nkuwa ekyo kyennyini ekiri mu Parliament wano ku mukutu gwa Red Zone Media. Bampita Sebambulidde Patrick waliwo wano ataddeko ka data ka 2,000 katono kazira mu liiso bannaye mwebale tontaliddeko linnya naye nga ka message katuuse bulungi nnyo. Ensonga ziri mu Parliament, abasajja bali mu kuwa akakiiko kano yakamanyiddwa nga Legal and Parliamentary Affairs Committee. Njagala kusomera abamu ku babaka abakatuulako nga sinagenda maaso na kiwandiiko kino kubanga ekiwandiiko ngenda kikuwa ekyo nga bw'okiraba kyonna naye kansooke nkuzeeko k'emabega. Akakiiko kano bakayita Legal and Parliamentary Affairs Committee from July 2024 paka olwaleero. Baka Stephen Mugabi ye chairperson waako akiikirira Bukoli County North wa NRM, kamyukibwa Honorable Taylor John Bugabula North County era wa NRM. Kuliko Honorable Odoi Olwero Fox Odoi West Budama North East wa NRM. Okia John Aniku wa NRM District Woman MP Madi Okolo, Honorable Kamusime Caroline District Woman Representative Ruchiga wa NRM, Honorable Kamugo Palmera Naisio District Woman Representative Budaka wa NRM, Honorable Achayo Lodu Ngora County wa NRM, Honorable Akirol Bosco Usuku County wa NRM, Honorable Werikie Peter Christopher Buburo County West wa NRM, Honorable Nkwasibwe Henry Ruhama County wa NRM, Honorable Oseku Richard Oriebo Chibale County wa NRM, Honorable Solomon Sirwanyi Bukoli County Central wa NRM, Honorable Solomon Sirwanyi mumujjukira abazze bagoberera. Ono y'omu ku babaka abeegabira obukadde buli wakawumbi akalamba n'obukadde olusanvu. Mathias Mpuga asooka afune obukadde 15,000 bali abalala bafune 4 kati Solomon Sirwanyi yali omu ku abo ababaka. Kakati mpuliriza bulungi nnyo nkumalireyo listi eno tutambule. Honorable Achia Remigio Pian County wa NRM, Honorable Tinkasimire Barnabas Buyaga West County wa NRM, Honorable Musingu Ziyona Ntungamo Municipality wa NRM, Honorable Odoi Bernard Onen Youth Representative Eastern Uganda wa NRM, Honorable Nambeshe John Baptist Manjia County wa NUP, Honorable Shamim Malende District Woman Representative Kampala District wa NUP oyo ali mu ddwaliro erisangibwa Nairobi mu ggwanga lya Kenya erimanyidwa Agakani. Ku miggo gye baamukuba ku Parliament yasembayo okutuula nga batugambye tulwanirira ku nsonga z'etteeka ly'emmwanyi. Kyamye mu Malende akyali mu ddwaliro paka n'olwaleero. Ate waliwo ababaka abalalira abakomyewo ku ssaawa ezijjako mu ddakiika ezitali nnyingi ogenda kubanga obifuna era bazze ku nsonga y'emu mbwera bazze kutulwanirira. Simanyi oba ne leero wanaavaayo abanaavaawo nga balina ebisago oba binaaba bitya, ffe tuli wano okubanga tubikutuusaako. Ku kakiiko ke kamu Honorable Medard Lubega Sseggona Busiro East officially wa NUP ebisigadde sejja binnyonnyola. Honorable Robert Sekitoleko bamunanika county wa NUP. Honorable Mathias Mpuuga Nsamba Nyendo Mukungwe division wa NUP officially naye ebirala sejja binnyonnyola. Honorable Adeke Ana Ebaju district woman representative Soroti wa FDC. Honorable Alumu Santa Sandra district woman representative Oyam wa UPC. Honorable Oduru Jonathan Erute county south wa UPC. Honorable Basalirwa Asuman Bujiri municipality wa Jema. Honorable Niwagaba Winfred Ndorwa county east wa independent. Honorable Katuntu Abdul Bugweri county wa independent. Honorable Zijanji David Livingstone Butembe county wa independent. Honorable Nsanji Patrick Kayongo Ntenjeru county south wa independent. Honorable Loki Peter Abrahams J county wa NRM. Honorable Chisembo Noelin district woman representative Kabale district wa NRM. Honorable Najuma Sara district woman representative Nakaseke district. Honorable Akampulira Prose Mbabazi ono mumujjukirira y'omu ku bali abeegabira eziri obukadde ebinabina district woman representative Rubanda district wa NRM. Be babaka abatula ku kakiiko akamanyiddwa nga Parliamentary Legal and Parliamentary Affairs Committee akayiseeyise mu bino era byekazudde bye bino byembadde nkusomera. 5.1 Cause 1 Amendment of Section 14 of Chapter 178. Clause 1 of the bill seeks to amend Section 14 of the Political Parties and Organizations Act to condition receipt of funds and other resources provided by government to political parties and organizations represented in Parliament. Bano abakakiiko kano benkusomedde baamaze okuzuula era ne bawa analysis yaabwe ne bawa ne recommendations kati bagamba tugenza okwetegereza nti twetaaga okukyusa akawaayiro oba section ye14 mu mateeka gafuga ebibiina by'ebyobufuzi mu Parliament. Era ne bategeeza twagala kino kibeere nga kiyimirira ekyokukwata ssente gavumenti ebeere nga efacilitatinga ebibiina by'ebyobufuzi naddala ebyo ebiri represented mu Parliament kati ng'ekibiina ekya NUP. Wulira recommendation yaabwe ekiwandiiko kinene nnyo sijja kiyitamu kyonna naye kati kankuwe recommendation yaabwe bagambye eki omaze okusubscribinga weebale amaze okubanga osubscribinga atanaba kubanga osubscribinga kikole mu bwangu obw'ekika ekya waggulu tugende maaso n'okubanga ate tukotosaako ensonga nga bwe ziba zigenda okubanga zitambula. Sebambulidde Patrick nze mbeerangawo wano ku mukutu ogwa Red Zone Media okubeera nga nkutuusaako buli ekiba kigenda maaso mu ggwanga erya Uganda. Wuliriza bulungi nnyo tubeere nga ate tutambula. Okusinziira ku bano abakungu recommendation yaabwe kikyo kye recommending oba kye bagamba kati kankusomere recommendation naye abantu bano ndoza kankutereko omukyalo ono ogende maaso n'okubanga otegeera bulungi nnyo kyenjogerako nga naye omulabako. Omukyalo oyo yasomye bino kubanga akakiiko katuulako ke kabikoze. The committee recommends nti akakiiko kalikomendinga bino wammanga. Funding to political parties should be conditional on the adherence of political parties and organizations to principles of tolerance, dialogue, and peaceful coexistence as proposed in Clause 1. The committee further recommends that government should only provide funds on other public resources to a political party or organization if the political party or organization is a member of and participates in activities of IPOD. Kyekiri kye nakugambye nti akakiiko kano Parliamentary Legal and Parliamentary Affairs Committee kalikomendinze era ne kategeeza nti twagala gavumenti oba mu ndaba yaffe y'ebintu twagala gavumenti eyimirize obuyambi bwonna obwa ssente obuweebwa ebibiina by'ebyobufuzi ebyo ebitakkiriziganya na mukago guli ogumanyiddwa nga ogwa IPOD. Kati bagamba twagala omuntu yenna waba wakuweebwa ssente zino oba obuyambi buno abeere nga amaze kubanga ali memba ku mukago ogwa IPOD. Kaakati gwampuliriza omukago gwa IPOD ogumanyi. His Excellency Robert Kyagulanyi Ssentamu n'ekibiina kya NUP baali baava dda mu mukago ogwo. Kakati awo ne tuvaawo. Parliament etudde bamaze okuprocessing ekyo era kyendi mugenda maaso n'okubeera nga nkutuusaako kakati gwe atannaba kubanga osubscribinga bino byonna oyinza obutabitegeera gye bujjako kubanga tuli wano kubanga tukuwa kasavu kanyama buli ekiva mu parliament ogenda kubanga ate wano wennyini wookifunira. If enacted, government fundings for political parties will be tagged on their membership and participation. Ababaka no bataddeko emikono era nkyagenda maaso n'okubanga nkuwa ekiwandiiko kino. Ababaka ab'ekibiina ekya NUP wamu n'ababaka bonna abava ku ludda oluvuganya bagenze maaso n'okubanga bategeeza eggwanga tutudde mu palamenti era weetuli nnyo okubeera nga tulwanirira bannayuganda. Biiruzi zino ziri bbiri gwampuliriza. Biiruzi ebbiri zigenda kuleetebwa mu ngeri ya njawulo. Eno yeesoose era saawa yakulaba kikiddako oba bagenda kugiyisa oba bagenda kugiyimiriza. Kakati wuliriza, sijja kusomera bataddeko mikono naye ngenda kusomera ezimu ku recommendations ezizza oluvannyuma. The committee recommends that iPod should be institutionalized as proposed in clause 2 and 3. Then ulira conclusion yaabwe. The committee recommends that the bill be passed subject to the proposed amendments attached here too. Ne bateekako emikono mingi naye sisobola jawula oba gy'abaani naye nkusomedde abatuula ku kakiiko era yeebadde ensonga lwaki mbadde mbakusomera. Bataddeko siginicha zaabwe ku kiwandiiko ekyo nga balaga nti bo bamativu n'ekyo era balikomendinga era basaba gavumenti nti kino kiyite mu bwangu ddala. Wano ne bakutegeeza nti singa kiyita ne kikyusibwa. If enacted, government funding for political parties will be tagged on their membership and participation in Uganda. Mukago ogwa iPod kakati gwe atamanyi mukago gwa iPod nja gukutegeeza. Omukago ogwo nzize nga ngubagamba interparty bakuta interparty organizations, interparty organization for dialogue. Omukago guno ngenda kubuli ebigukwatako ebitonotono ebyafaayo byagwo naye njagala osooka osubscribing eggwa amaze okubanga ate otugwa ku mukutu guno atanaba kubanga osubscribing kikole tujja kubanga ate tutambula ffenna ebbanga lyonna. Nyongera okwebaza mwenna abajja mu comment section ne muteekayo obubaka bwammwe ate ne tubanga ensonga zitambulira ddala bulungi nnyo. Kakati nga bwe nninde eggulire ddala eriva mu parliament era ku nsonga y'emu kati ndi wano okubanga ate byonna mbikutuusaako nga bw'osubscribinga nga bw'ogenda mu comment section teekayo obubaka kansooka enziremu mpitayite mu bubaka bwammwe then oluvannyuma tweyongereyo n'eggulire eriva ate mu parliament. Bamwise Okeda David, my bro, you speak in English man. Angamba, I speak in English. I present both in Luganda and English. When I get when I get any document concerning this issue, I read it as it is in English. Then I have to translate it into Luganda because we have a large audience. Twina side zonna tetusobola kukozesa lulimi lumu. Newankubadde nga olulimi Oluganda ye mother language yaffe, olulimi lusinga otutegeera. Ono bamwise Serubugo Ibra. Webale kubanga ogoberera Namugenyi Silivia, webale kubanga kwoli ono bamwise Stamase genda mu Bungereza owulire Oluzungu. Stamase webale kubanga kwoli Mugisa Sulai, webale kubanga nayo kwoli Uganda zukuka. Okay bro, thank you. Webale kubanga ogoberera ina gyosinze okubanga gyotulabira bannanga abanyambyeko mu nsonga ya kadata namukose salinina mwannyina webale kubanga obeerayo ate webale kubanga kwoli ku mukutu guno kyonna kyokola kya mutawana nnyo. Bamwise Sofai Neko, webale kubanga nayo kwoli Nyombi Francis, webale kubanga okyaliko message etuuse bulungi nnyo. Bamwise Bone Mugisa Bone, webale kubanga kwoli nagamba remember UMPs no one is above one lower just only we are waiting time will come bwatu bwategeeza. Isaac Jordan, webale kubanga kwoli nagamba buli mubaka ajja kukola ki. Kabanda Shira webale kubanga okyaliyo. So Sophia nagamba Sebo, the names you are reading are the one who proposed the bill to pass through oba nedda. Amanya gensomye Sophia, amanya gensomye, the names I have read are those members on the committee that analyzed and processed and eventually they recommend that these bills should be passed and the constitution should be amended in regard to these bills. Amanya gensomye ge gababaka batula ku kakiiko ako aka reviewinze, aketegereza, akaanalyzinze era ne kaleeta bye kazudde ne basuggestinga nti ebbago lino oba amateeka gano gakyusibwe. Ababaka abo benkusomedde kitegeeza ke kakiiko akaatudde ne kaba nga kayise. Jjukira nakugamba ebbago lino erya presentingibwa for the first reading, speaker yasindika mu bukiiko buno. Obukiiko bubiri bwenzize nkugamba, akakiiko akamu bakayita Legal and Parliamentary Affairs Committee kakeekebejja etteeka eryo. Then liri erya UPDF Amendment Bill lyasindikibwa mu kakiiko akamayiddwa nga Defence and Internal Affairs Committee, nako keetegeeza era nako nja kujja mbeere nga nkakuwa. Amabago gali abiri gonna gazze olunaku lumu. Ebbago ery'ebibiina by'ebyobufuzi lyeryo erimaze okuba nga lisomebwa. Ebbago erya UPDF lyeryo erigenda okuba nga lireetebwa essaawa yonna. Lowedi, we shall hear later in the day. The bill is hereby recommended for the third reading and the presidential assent. Ebwate bwagambye. Thank you bro. Ono bamuyise Mwesigwa Aaron we bali kubanga kwoli. Nyangoma Scovia, we shall see them by their works. We bali kubanga kwoli. Odwari Moses Edi Mutwe bamuleese ya. Edi Mutwe bamuleese mu kkooti era ge mawulire egenjagadde okubanga ate nago nga kutegeezaako gategeere bulungi nnyo. Waliwo ekifaananyi wano kyenjagala okukuwa mutegeere bulungi nnyo iPod kiki kyekola. iPod ebibiina by'ebyobufuzi ebikiikirirwa mu Parliament bituula ne bitandika okukolanga enteeseganya ez'okumukumu, era enteeseganya zino olumu tezitera kuvaamu yadde ekibala oluvannyuma lw'okuba nti kizze nga kizuuka, era nga y'ensonga lwaki His Excellency Robert Kyagulanyi Ssentamu n'ekibiina kya NUP baagano zituulamu. Bo bagamba nti bagenda ne bateesa, wabula bwe bavaayo bapoozinga ne bafuna ekifaananyi nti General Museveni atudde n'ab'ebibiina by'ebyobufuzi ate bye bateesezzaako ne batabiteeka mu nkola. Kakati eyo yali emu koze summit eza iPod eyatuula mu mwaka gwa 2018, era nga mu iPod eyo mu lutuulo olwo kwaliko abakulembeze b'ebimu ku bibiina ebyakkiriza ne bituula mu lutuulo olwo. Kwaliko Nobert Mao nga akulembera ekibiina kya DP, kwaliko Asumani Basaalirwa nga akulembera ekibiina kya Jema, kwaliko General Kaguta Museveni nga akulembera ekibiina kya NRM, kwaliko Jima Akena mutabani wa Milton Obote nga akulembera ekibiina ekya UPC. Kakati bano baali bamaze okusesenkana mu lutuulo olwo era nababaako bye bakkaanyaako. Kigambibwa nti General Kaguta Museveni n'ekibiina kya NRM tebabiteeka mu nkola ebyo bazze bateesaako, era ng'eyo y'ensonga eyaviirako His Excellency Robert Kyagulanyi Ssentamu n'ekibiina kya NUP okugamba nti ffe guno omukago tetujja kugukkiriza. Ensonga lwaki tetujja kugukkiriza yeeyo gye nkugambye nti ebintu tebiteekebwa mu nkola, era n'olwekyo ne bategeeza nti ffe guno omukago gwa iPod tetujja kugubeeramu. Kati gwampuliriza oluvannyuma lw'ebyo byonna abasajja kirabika kibadde nga kibanyigiriza okusinziira ku bye tulaba, era ne bategeeza mbu tebajja kubeera nga bakola ki batula mu kibiina ekyo. Kati we twogerera abasajja batandise enteekateeka ey'okulaba nga ebbago lino liyita lifuuka etteeka oluvannyuma bibeere nga kyampaka ekibiina ky'ebyobufuzi ekitatobodde kubeera nga kituula mu mukago guno gwa iPod kibeere nga tekiweebwa buyambi obuli mu mateeka obuweebwa, kubanga obuyambi buli mu mateeka era singa tebubadde mu mateeka nkakasanga gavumenti ya General Kaguta Museveni balina obusobozi obwandibadde nga baayimiriza dda sente ezo zandibadde tezikyaweebwa kibiina kya National Unity Platform, wabula kati zibaweebwa oluvannyuma lw'okubeera nti ensonga eyo eri mu mateeka ate yabuwaze okubeera nga ebibiina bino biyambibwako. Kakati gwampuliriza ndowooza ensonga eyo etegeerekese bulungi nnyo, naddala gwamaze okubeera ng'osubscribinga tutegeerekese tutegeeraganye nga bwe ngenda maaso n'okuba nga nkutuusaako byonna ebiva sayidi eyo. Abagala okumanya ku nsonga eza Edi Mutwe, njagala okutegeeza nti Edi Mutwe ali mu kkooti era amaze okubeera nga aleetebwa. Kakati njagala tuddeyoko mu Parliament nkutuuseeko butereevu ensonga nga bwetambula. No bamwise Mulangira Ddamba we bali kubanga kwoli, Benedict Asacha we bali kubanga kwoli, Bwambale we bali kubanga nayo kwoli, message etuuse bulungi nnyo. Banange bampita Sebambulide Patrick abanyambyeko mu nsonga ya kaddata abateekako bu message mbeebaza nnyo we bali kubanga mukyagoberera ate mwe bali kubanga we muli muyimiriddewo ku lwaffe okulaba nga ate tubatuusaako ensonga nga bwe zigenda maaso n'okubeera nga zitambula ku mukutu guno ogwa Red Zone Media. Abamaze okubanga mu subscribinga kyokola kya mutawana nnyo gwe amaze okubanga osubscribinga atanaba kubanga osubscribinga kikole mu bwangu obw'ekika ekya waggulu ensonga nga zino zibeere nga ate tozimiisinga gwe ampuliriza. Njagala kubanga nkuzaayo mu Parliament butereevu ofune ekigenda mu maaso ofune butereevu ekigenda mu maaso mu Parliament y'eggwanga erya Uganda, nga Parliament egenda mu maaso n'okubanga eyisa amateeka genkakasa nti gwe munnayuganda oyinza okuba nga togeetaaga naye ba abasajja bakalambidde era bagamba bajja kugayisa. Kakati omaze okusubscribinga nze nkutuuseeko ebiva sayidi eyo. Wuliriza, tuli ku tteeka erimanyiddwa nga Political Parties and Organizations Act. Kansome obubaka bwa mumulundi ne lwaki sigenda direct mu parliament nemba ngamba tuusaako ebigenda maaso. Obubaka bannaye mbusomye ngezezaako okukola ekisoboka okulaba nga obubaka bwonna bubatuukako naye ndowooza tukkiriziganye nsooka enzireyokko mu parliament mbawe ekigenda maaso then oluvannyuma tugenda kubanga ate tweyongerayo n'ensonga kubanga nze ndi wano okubeera nga byonna ebigenda okuva sayidi eyo bibatuusaako mu mbeera ey'ekika ekya waggulu ate ggwe amaze okuba nga osubscribinga ogende maaso n'okuba nga tobimiisinga. Wuliriza bulungi nnyo nga bwe tugenda maaso njooza tugenda kuba nze kansooka enveeko engenda kukomawo mu dakiika si nnyingi tubeere nga tutambula. Omukutu baguyita Red Zone Media abamaze okusubscribinga mbeebaza abatana subscribinga mu kikole tubeere nga tutambula. Kakati nzizayo mu parliament okulaba nga mbatuusaako embeera nga bwegenda maaso n'okuba nga etambula. Tuwuliziganye mu updates eziddako naye sooka olabe ekiri mu parliament nga bwe tugenda maaso n'okuba nga tutambula.
The Supervising Ministry, Justice and Constitutional Affairs, the political parties represented in Parliament were never consulted by the movers nor the committee. No other stakeholder, including members of Parliament, who had sought, albeit in futility, to move private members' bills on reforms touching political parties and elections, were accorded an opportunity to submit before the committee. The House may recall the vehement submission by the esteemed founding former first son of Uganda, the Honorable Jimmy James Michael Akena Obote, MP Lira City East and party president of the two-time party in government, for those who don't remember, 1962 to 1971 and 1981 to 1985, who is also a member and a former chair of the IPOD. In his submission on record of this House, the Honorable Jimmy James Michael Akena labeled the bill diabolical. The minority found it necessary to recast the dictionary meaning of the word diabolical as below. It means characteristics of a devil, or so evil as to be suggestive of a devil. The second dictionary definition is disgracefully bad and unpleasant. The minority invites the House to pay kind attention and consider the concerns of the party president of UPC, and also recall the concerns of the Honorable Asuman Basalirwa, the party president of JEMA, in as far as implementation of sections 14 of the Political Parties and Organizations Act is concerned. There is no doubt in my mind that the leaders of the political parties in IPOD, who are not members of this House, I have listed them: the Honorable Chagulanyi Robert Sentamo of the official opposition party, no; the Honorable Amuriat Patrick Oboy of FDC, One Uganda, One People; the Honorable Norbert Mao of DP, Truth and Justice; and Mr. Magara George Williams of the PPP, if given the opportunity, would equally have opposed this bill, which has been moved without their views. The minority also observes that the regulator of the political parties, which is the Electoral Commission, with powers to sanction political parties and organizations, has powers to sanction political parties and organizations. The sanctions available to the Electoral Commission include deregistration, which is an equivalent to a death sentence to a political party and organization. The minority is of the considered view that the Electoral Commission has all the tools, should it be necessary, to deal with any political party which is found culpable. The minority did not receive any single evidence of complaint filed by the movers to the Electoral Commission, and further that the Electoral Commission failed to act on such imaginary violations. This is the finding of the minority. The minority finds that the bill is diabolical. You can recall those definitions, and miserably falls short of meeting the provisions of Article 8A of the Constitution in as far as public participation in enactment of legislation is concerned. It is further found that the speed at which the Political Parties and Organizations Amendment Bill 2025 is being rushed is greatly disconnected with the urgency required and expected of Parliament to solve the contemporary challenges facing Ugandans in the areas of decent jobs, improvement in the healthcare services, provision of quality education, delivery of fair and speedy justice, amongst others. I think I missed. Let me rephrase that. It is further found that the speed at which the Political Parties and Organizations Amendment Bill 2025 is being rushed is greatly disconnected with the urgency required and expected of Parliament to solve the contemporary challenges facing Ugandans in the areas of creations of decent jobs, improvement of healthcare services, provision of quality education, delivery of fair and speedy justice, amongst others. The other dissenting point is the unreasonableness and the rationality of the bill. The main justification of the bill is stated by the movers to be to condition and obtain commitment of political parties and organizations to principles of tolerance, dialogue, and peaceful coexistence. Thank you, Madam Speaker. The main justification of the bill is stated by the movers to be to condition or obtain commitment of political parties and organizations to principles of tolerance, dialogue, and peaceful coexistence. The justification is shallow, unreasonable, irrational. At registration, all political parties carefully choose their own principles embedded in their constitutions which guide them, and these are registered with the Electoral Commission. In the absence of the express provisions in the constitution of political parties, the recourse is to the national objectives and direct principles of state policies and Articles 29 and 69 to 76 of the Constitution of the Republic of Uganda. Finding, the minority finds that the Political Parties and Organizations Amendment Bill 2025 is frivolous, vexatious, unjustified, unreasonable, irrational, and irrationally false shortly acute of the constitutional parameters set out in the national objectives and direct principles of the state policy. Conclusion: the minority having found the following: 1, that the provisions of the bill have the effect of imposing a charge on the consolidated fund contrary to Article 93 of the Constitution of the Republic of Uganda. 2, that the bill interferes with both constitutional and statutory mandates of Parliament, Cabinet, Electoral Commission, National Youth Council, National Women Council, and potential amendments by infection, several acts of Parliament. 3, that the bill contradicts the government policy of rationalization on creation of new expenditure centers, such as the 2 organs proposed in this bill. 4, that the bill is diabolical and miserably falls short of meeting the provisions of Article 8A of the Constitution as far as participation in enactment of legislation. 5, the Political Parties and Organizations Amendment Bill is frivolous, vexatious, unjustified, unreasonable, and irrational. Now, therefore, it is recommended to Parliament as follows: that no question be proposed upon the Political Parties and Organizations Bill. 2, motions seeking leave to introduce private members' bills should be subjected to rigorous scrutiny by way of extensive debates on the justification for the peculiar circumstances to warrant the grant of leave. If I may add, government must first fail reasonably to provide a bill to have a justification for private membership. B, the Minister of Finance, Planning and Economic Development be cautioned. The Minister of Finance, Planning and Economic Development be cautioned to execute the mandate of the ministry diligently and avoid late-night escapades of issuance of defective certificates of financial implication. Parliament avoids entangling and entertaining motions and bills arising out of petty quarrels and disagreements between individuals and institutions. Lastly, that the Business Committee of Parliament should convene on more regular basis to conduct business as provided in the rules of procedure. Madam Speaker, before I conclude, when a point of law or a point of procedure is raised in this House, it is my humble prayer that you make a ruling substantially. It cannot, a point of law or a preliminary objection cannot be put to vote. That preserve is entirely for the presiding officer. the ruling must be on the record. You cannot say because the points of law are raised. This is provided in our rules, and I request that where I have raised a point of law touching the Constitution, touching our rules, before you give a formal ruling, it is now hereby reported by this person who signed the minority report. Thank you very much.
Thank you, Honorable Do. The other minority? In the absence of the minority report, Attorney General, we need a response to the issues that are raised, since the government is the one that gave a certificate.
Thank you, Right Honorable Speaker. Right Honorable Speaker and Honorable colleagues, I have had the opportunity to read the certificate that was issued by the Ministry of Finance. The plain reading of the same is saying that while there are expenses expected to be used, the money is already in the budget. So what I understood from that there was no imposition. Government had already provided money. This bill is simply reorganizing. It's just simply reorganizing what already exists. So there's a National Consultative Forum for which money has been provided to run the affairs of the National Consultative Forum, and the bill seeks to reorganize the National Consultative Forum.
Does it have an effect on the money that we have always allocated?
No, Right Honorable. That's our understanding. That doesn't have any other charge. Now, on the issue of rationalization, I again, Right Honorable Speaker and Honorable colleagues, the National Consultative Forum consists of all the members of all the political parties registered in Uganda. The iPod that is sought to be introduced, from my understanding, is only relating to a subset of those. All the political parties which are represented in the House are members of the National Consultative Forum. So they are saying we shall have a meeting of the 43 or whatever number you have, but we shall also have another meeting. So I don't think there is anything to do with rationalization here. So I don't know the other issue about the ruling of, I think, Right Honorable Speaker, we may run into a problem if we take the interpretation given by Honorable Odur. We are always discussing matters of law in the House. The principal purpose for which we are here is legislation. And at all points we are discussing matters of law. So if the Speaker, every time we speak here on a point of law, must pass a rule, then I think that's a wrong interpretation. I have not seen that provision in the rule. Right Honorable Speaker, lastly, this is a minority report. There's been a majority report, a minority report, so the members should now be allowed to debate those reports and then make a decision on how to proceed. I beg to
And these reports are basically to form a debate on the next step. So we'll now open the debate on yes.
Madam Speaker, Madam Speaker, I want to draw your attention to this, the wording.
Honorable, just a minute, Honorable Attorney General, the certificate where it says there has a financial implication, maybe you could make a clarification on that.
Right Honorable, the certificate says this bill has a financial implication which has been provided for in the budget of this institution. Okay. So it is not an imposition of a charge. It is saying that from my reading of this, whatever money you're going to use to do this is already there. So it's not an imposition. They are not imposing a charge on the they're actually just spending what has been provided.
Okay.
Madam Speaker, the records of my submissions are already with you, but I want to remind you on this, that before we go to debate, you resolve this matter. Rules regarding settlement of financial matters. A question shall not be proposed upon a bill, motion, an amendment bill, or amendment to a motion which has not been introduced or moved by a minister. If, in the opinion of the Speaker, the object of the bill, motion, an amendment bill, or amendment to the motion is to make provision for the following: A, the imposition of taxation or alteration of taxation, otherwise by reduction, not applicable to this. B, the imposition of a charge upon consolidated fund or other public fund of Uganda, or the alteration of any such otherwise by reduction. And C, the payment issue, etc. The point I'm making is that your opinion as the Speaker let me finish. Your opinion as the Speaker is first required. If the Speaker rules the presiding officer, because these records may form part of other proceedings, so you cannot, as the Speaker, just wish it away. If, in your opinion, what is your opinion on this point?
This certificate, Honorable, this certificate was given by government. And the certificate that was given by government, I have asked government to respond to the issue whether it imposes a tax or it has an effect on Article 93. And government says it does not have an effect on Article 93. And if government says it does not have, and that is the legal advisor of government, and says it has no effect, then it doesn't. Is a legal advisor, yes, finance?
Right, Honorable Speaker, through my minister, I wish to state that the certificate of financial implications which we issued does not create additional financing requirements by government. We have been providing for a budget for political parties. This exists in the budget which we are running now and the budget which we passed on Thursday. What this law is requiring is conditioning access of this money to certain rules and standards. Otherwise, the money which we have been providing will remain the same. And this is why we said this certificate will not impose new financing requirements. It will be financed within the already provided for budget.
So it has no existing imposition of levy on 93.
Madam and honorable members, you will bear with me. If you listen carefully to the submission of the minister, he does not deny a charge on the consolidated fund. All he's saying is that there will not be an additional. The wording of the Constitution and the rules does not include the word additional. It just is a charge.
Honorable Dole, we have been providing for money for political parties in this house. And in provision of that money goes to political parties in the house. And that money goes to political parties. What the law is now saying, we have parties in the house that do not subscribe to iPod. Now, those parties that are in the house must first subscribe to iPod for them to be able to get what? To get part of this money. There is no additional money that is being added on political parties. It is exactly the same amount that has been there that is going to be distributed according to the numerical strength in the house. But the law is also saying that if you do not want to cooperate by being part of iPod, then you do not qualify. Meaning that if you don't participate in iPod, the money that is going to be distributed to the other parties that are in IPOD actually will be within them, and it increases on their money. Yes, Dr. Chris. Let's first have Chris.
Thank you very much, Right Honorable Speaker. I think the Honorable Dur should not mislead the House. What Article 93 refers to is for a private member's bill to introduce additional burden, a charge or a tax, which is not applicable in this case. There is no new charge or tax being introduced by the bill. And therefore, I think, and he knows it, but he's just taking Parliament for a ride. So I just invite you to cease fire and let the House debate these reports.
Honorable Akamba, Honorable Ole.
Thank you, Right Honorable. Right Honorable, the Article 93 of the Constitution is very clear, and it does not, the current bill does not in any way offend the article, because, Right Honorable Speaker, I read the article verbatim. It says, in summary, it prohibits Parliament from proceeding on a bill or an amendment unless it is done on behalf of government which imposes a charge on any public fund. Right Honorable Speaker, the Political Parties Act, which is already in existence, created a charge on the public fund, and that's not in doubt. All what the bill is saying is how should this money be spent. It does not in any way suggest, there is no single provision that says or proposes that there will be another charge made on the consolidated fund. So in my opinion, the bill is constitutional and it does not offend that Article 93 in any way.
Thank you. Let us do wind up and.
Thank you, Madam Speaker. This is my last, and then it can be debated. I am submitting that without prejudice to the issues debated by the Right Honourable Speaker, I request that, as per the rules, you give your ruling so that the House can proceed. I
have given my ruling that it does not have an effect on the consolidated fund, Article 93, as already stated by the legal advice of government and stated by the Minister of Finance. Honourable members, physically we have 148 members, and then virtually we have 49 members. That takes us to 197. Yes. Honorable Hati.
Madam Speaker, we want to thank the committee, but also to appreciate the issues raised by the minority report, and we have had clarification that actually this bill has no imposition of extra charges. We have also, from the report of the committee, the majority committee, heard that the bill is not diabolic. It's actually intended to organize the current situation of political parties. And having listened to both sides, Madam Speaker, I wanted to move that this House can move to another stage so that we proceed with the bill. I beg to move.
Seconded by Baviko Eda Council locally by the whole House with the exception of Odur. I put a question that the Political Parties and Organizations Amendment Bill 2025 be read a second time. Those in favor say on the contrary, nay. The ayes have it.
The Political Parties and Organizations Amendment Bill 2025, Bills Committee stage. Clause 1.
Procedure.
Chair.
Procedure, Honorable Speaker.
Yes.
As a member of the IPOD Summit, I am finding it extremely strange that I cannot even put input on the goings on of IPOD on record. You see, Madam Speaker, every parliament we have debated a memorandum, and there's a current memorandum which is standing for IPOD. And the chair of IPOD for the last 4 years has been NRM. And if there's any breach, it is NRM who have failed to call a summit or even a council meeting. So it is important that we deal with this actual issue, because what are we correcting? What is the sickness? What is the disease we're correcting? At the moment, the summit has not sat since NRM has been in the chair for 4 years. Yet it's supposed to be 6 months. The provisions which are being brought now are being brought in bad faith, because in the last parliament, under the chairmanship of Honorable Boss of Boss, IPOD brought it, and I personally presented them to the same committee. Because the increased funding which came in a supplementary of 2020 had IPOD in it. And how was that money to be shared? At that time, political parties were sharing 10 billion per annum. Under the IPOD arrangement, it was increased to 35, with 5 billion going as the 15%, another 5 billion for covering the other 15%, and then 70%, the 25 billion, was on numerical strength. At that time, the president acknowledged that NRM acted in bad faith by not allowing that amendment to pass. They acted in bad faith. The words of the president, unchristian. And now we are going through a process to undermine everything. There's no dialogue here. If we talk about dialogue as a political party, as a leader of a political party, as the political party which first held the first summit, from 2009, the first summit was held in December 2018 under my chairmanship. And the principles which we're debating is what we agreed in that. It's under the Democratic Party that they put flesh on those principles. And honestly, Madam Speaker, are we proceeding well when we cannot discuss this issue? I have not been consulted as a leader of the summit. As a political party, we have not been consulted. How is it that we're debating this issue? And that is why I say it is diabolical. It is not done in the interest of the political players. I speak for UPC. My brother Asuman is not part of this. And I'm thankful that Mao is not here to embarrass himself. This is wrong. And we shall all be judged.
Thank you.
Let us be honest.
Honorable members, as I thought the member raised her issue. You still have a gap as members of IPOD to go and ensure that you discuss this issue and maybe ask the president not to assent. Clause 1.
Clause 1.
Clause 1.
Madam Chair, the committee proposes an amendment to Clause 1 of the bill in the following terms. Clause 1 of the bill is amended by substituting for the proposed subsection 2 the following. So the new subsection 2 is, notwithstanding subsection 1 of the government, notwithstanding subsection 1, the government shall only provide funds for or other resources to a political party or organization referred to in subsection 1 if the political party or organization is a member of the inter-party organization for dialogue and participates in activities
of the Inter-Party Organization for Dialogue. Justification for clarity to require political party and organization to not only be a member of the Inter-Party Organization for Dialogue, but also participates in the activities of the Inter-Party Organization for Dialogue.
Private member.
Procedure.
Right Honorable Speaker, I concede.
AG.
I don't have any objection.
I put a question that clause 1 be amended as proposed. Those in favor say on the contrary, nay. The ayes have it.
Clause 1 as amended.
I put a question that clause 1 as amended stands part of the bill. Those in favor say on the contrary, nay. The ayes have it.
Clause 2.
I put a question that clause 2 stands part of the bill. Those in favor say on the contrary, nay. The ayes have it.
Clause 3.
I put a question that clause 3 stands part of the bill. Those in favor say on the contrary, nay. The ayes have it.
Title.
I put a question that the title stands part of the bill. Those in favor say on the contrary, nay. The ayes have it.
Motion for resumption of the House.
Honorable Nakut.
Right Honorable Speaker, honorable members, I move that the House do resume and the Committee of the Whole House reports thereto.
I put a question that the House resumes and the Committee of the Whole House reports thereto. Those in favor say on the contrary, nay. The ayes have it.
Report of the Committee of the Whole House.
Honorable Nakut.
Right Honorable Speaker, the Committee of the Whole House has considered the bill entitled the Political Parties and Organizations Amendment Bill 2025 and passed it with amendments to clause number 1.
Motion for adoption of the report of the Committee of the Whole
Honorable
House.
Nakut.
Right Honorable Speaker, I move that the House adopts the report of the Committee of the Whole House.
I put a question that the report of the Committee of the Whole House be adopted by this House. Those in favor say on the contrary, nay. The ayes have it.
Bill third reading, the Political Parties and Organizations Amendment Bill 2025.
Honorable Nakut. Yes.
Thank you, Madam Speaker. Madam Speaker, I would like to raise the issue touching the Constitution and our rules on quorum. I can confirm the number of members present. I request that you put on record the number of people attending online so that we can confirm that the 47 you mentioned is correct.
Honorable Odur, I mentioned it. I don't know why you doubt what I'm saying. I did it, I mentioned it, and I still maintain what I mentioned. Honorable Nakut.
Right Honorable Speaker and honorable members, I move that a motion that the bill entitled the Political Parties and Organizations Amendment Bill 2025 be read for the third time and do passed.
I put a question that the Political Parties and Organizations Amendment Bill 2025 be read the third time and do pass. Those in favor say on the contrary, nay. The ayes have it.
A bill for an act titled the Political Parties and Organizations Amendment Act 2025.
Title settled and the bill passed. Next item.
Item 5 on the order paper. Bill second reading. The Uganda People's Defence Forces Amendment Bill 2025.
Honorable members, you recall on Tuesday 13th, 2025, the Minister of Defense and Veteran Affairs tabled the bill, the Uganda People's Defense Forces Bill 2025 for the first reading. The bill was read for the first time and referred to the Joint Committee of Defense and Internal Affairs and the Committee of Legal and Parliamentary Affairs pursuant to Rule 200, the rules of procedure. The Joint Committee is now ready to report, and pursuant to Rule 136(1) of the rules of procedure, I will invite the Chair of Defense and Veteran Affairs to move a motion to that effect. Defense and, the Minister of Defense and Veteran Affairs to move a motion to that effect.
Right Honorable Speaker, I beg to move that the bill entitled Uganda People's Defense Forces Amendment Bill 2025 be read for the second time.
Seconded. Seconded by Honorable Bahati, Honorable the Vice President, Honorable Jessica Lupo, the Prime Minister, Honorable Navanja, the Honorable Hajat, the Deputy PM, Prime Minister, Honorable Bahati, Karamoja Affairs, Honorable Kuris, Honorable Acheng, Honorable Namiliango, Honorable Anifa, Honorable Musasisi, Honorable Mbadi, Honorable Akelo, Honorable the youth MP, Fred, Honorable Minister Muhosi, Honorable Finance, Honorable Kasaija, Shatis, Adoa, Honorable Elwelu, Honorable Kasai, Honorable Government Chief Whip, by the whole House with the exception of Honorable Do. It has to be on record. Yes. Would you speak to your motion?
Honorable Speaker and colleagues, the record of this House has it that this bill is actually intended to rectify, to remedy the existing defects in the law. The last time this Parliament handled this bill was 2005, and the Uganda People's Defense Forces Act 2005 was enacted in 2005 to provide for the regulation of the Uganda People's Defense Forces in accordance with Article 210 of the Constitution. It repealed...
Honorable, I meant Honorable Muhes, not Muhos. Muhes, not Muhos. And Honorable Tafire.
It repealed and replaced the Armed Forces Pensions Act, Cap 295, and the Uganda People's Defense Forces Act, Cap 307. Since 2005, the defense sector has undergone significant transformation arising from both emerging threats and opportunities. Several of them were unforeseen and not adequately addressed by the Uganda People's Defense Forces Act, Cap 330. The Act, for instance, did not provide for the provision of health care for the officers and management of militants. It did not also provide for the management of military veterans, management of pension and conferring of service medals by the defense forces. It is important, Right Honorable Speaker and colleagues, to note that since 2005, the administrative structure of the Uganda People's Defense Forces has evolved. This in turn has led to the Special Forces Command and the Reserve Forces being elevated from divisions under the Land Forces to independent services. The amendment before you today has taken this into account. Additionally, following the judgment of the Supreme Court in Constitutional Appeal number 2 of 2021, Attorney General versus Honorable Michael Kabazikuruka, that name there is need to align the provisions of the Act with the Supreme Court decision. This bill accordingly gives effect to the orders and recommendations of the Supreme Court. And Right Honorable Speaker and colleagues, I believe that the justifications others embedded in the remedies proposed in the bill, one of them is to align the Act with the new government policies and the command, control, and other administrative structures of defense forces. Another one is to improve the welfare of the officers and militants of defense forces, to address the glaring gaps in health care by providing for health care for officers and militants. 3, to harmonize the management of military veterans. 4, to provide for the decentralization of pension authority from the Ministry of Public Service to the Ministry of Defense and Veteran Affairs. 5, to enhance disability compensation to enable fair payment of compensation to officers and militants of the defense forces for injuries sustained while on duty and address the resulting challenges faced by officers and militants living with post-traumatic stress disorder. 6, to restructure and re-establish the courts-martial in the defense forces in accordance with Article 129(1)(d) of the Constitution and prescribe their jurisdiction to provide for the membership and qualification of presiding officers of the courts-martial and for the independence of the courts-martial. 7, to provide for appeals from the courts-martial. 8, to prescribe exceptional circumstances under which civilians may be tried by the courts-martial. Next is to establish a military courts department which shall be responsible for the administration of justice within the defense forces and provide for its membership. Again, to establish a disciplinary unit within the defense forces which shall be responsible for the discipline of the members of the military courts department. And finally on that is to prescribe the arms and ammunition which are the monopoly of the defense forces and classified stores of the defense forces. Right Honorable Speaker and Honorable colleagues, this law is not about civilians being before courts-martial. This law is about civilians who voluntarily acquire arms, equipments of violence. This law is also about the civilians who voluntarily masquerade as militants. This law is about those who would commit offense with the military or with the help of any military officer to be tried as proposed. Right Honorable Speaker, I want to dispel the fear that this law is targeting 45 million Ugandans. That's a lie. This law is targeting those people who have preoccupation in their minds to commit offense against Ugandans. This law is to protect Ugandans, the vulnerable Ugandans, against violent people who have firearms or who behave like military personnel. I beg to submit.
Thank you, Honorable Minister. I now invite the chair to give us his report.
Right Honorable Speaker, I wish to lay on the table minutes and record of processing of the bill as was referred to us. I beg to lay. Right Honorable Speaker, and I will summarize. On the 13th May 2025, the bill was referred for the first time reading to the committee, and according to Rule 200, a consolidated.
Yes.
Right Honorable Speaker, the chair of the committee intends to dissuade the House that there is no dissenting report. There is a dissenting report that was submitted to the chair of the committee, and rightfully so, he should have probably made us aware that it is there and almost signed by half of the committee.
The chair will bring that. Just be patient, it will come. The chair, after reading his report, will call for the dissenting what? Views.
Right Honorable Speaker, just a few seconds ago, I have been handed over the minority report. I wish to lay the minority report. And there was no intention whatsoever, but the fact is, if there is a second one, you present. But Honorable Speaker,
another member stop smuggling minority reports in the House. The reports must be received, we upload them and we handle them.
Thank you.
Nobody will be denied to present a minority report, but just bring them in a formal way.
But Honorable Speaker, I wish to present the report of the consolidated committees of Defense and Internal Affairs and Legal and Parliamentary Affairs. This bill addresses the policy principles, and briefly, it streamlines the composition of the defense forces and establishes healthcare service for its members. The bill creates a medical board. It defines service offenses. It defines.
The report is being presented.
Let him finish his report.
Yes.
Hansard, capture all the reports. Capture all the reports. Yes, Honorable Wilson, go ahead.
Thank you, Right Honourable Speaker.
Are you Wilson? What is it?
Right Honourable Speaker, the procedural point I'm raising, I sit in the Committee of Defense and Internal Affairs. Right Honourable Speaker, you gave the committee the task to look at the bill and come up with the report. And when we were writing the report on Monday, before we reached half of our report, the chairman told honorable members that they are going to Entebbe to attend the caucus and they will come back. We shall continue with the report. Right Honourable Speaker, the chairman did not come back, and we did not continue with writing our report. Is it procedurally right, Right Honourable Speaker? I don't know where the report came from. Let the chairman clarify to members, because we did not complete writing our report on that day. Right Honourable Speaker, we need to be very serious. And it's so bad to keep on smuggling what is not agreeable by honourable members. Where did you get this report from? Yet the committee did not complete. Right Honourable Speaker, let us put the record right. In fact, we did not complete working on this report. And we did not process it.
Honorable, where did you get your dissenting views for you to write a minority report? Because the minority report is, say it. The minority report is signed by you. Where did you get the dissenting view? Chair, continue.
Thank you, Right Honourable Speaker. Right Honourable Speaker, the bill streamlines composition of defence forces. It establishes the health care service of the members. It creates a medical board. It defines service offences, military courts, and reserve force, while restructuring the courts martial per Article 129, 1D of the Constitution. The proposed qualifications of the chairperson of the courts martial to ensure independence and allow for appeals. This bill specifies circumstances under which civilians may be subject to military law and outlines the offences tried under courts martial. Additionally, Right Honourable Speaker, this bill establishes a military courts department, a disciplinary unit for enforcing discipline within the military court system. It prescribes defence forces exclusive arms and ammunition. It manages veterans' affairs and repeals the Uganda Veterans Assistance Board Act Cap 221 and related matters. This bill, Right Honourable Speaker and Honourable colleagues, addresses the defects in the existing law. The UPDF Act, the Uganda People's Defence Forces Amendment Bill 2025 amends the UPDF Act Cap 330. This act, enacted in 2005, regulates the Uganda People's Defence Forces as provided under Article 2010 of the Constitution, replacing the Armed Forces Pensions Act Cap 295 and Uganda People's Defences Act Cap 307. Notably, the defence sector has undergone significant transformation since 2005, driven by emerging threats and opportunities, many of which the Act does not adequately address. The Act did not include health care for the officers and militants, management of military veterans, pensions management, or service medals conferred by defence forces. Since 2005, the UPDF administrative structure has changed significantly, with Special Forces Command and Reserve Force elevated to independent services. The Uganda People's Defence Forces Amendment Bill 2025 reflects this evolution. Additionally, Right Honourable Speaker, the bill seeks to align the Act with the Supreme Court decision in the Constitutional Appeal number 2 of 2021, which is Attorney General versus Honorable Michael Kabaziguruka. What are the objects of this bill? It seeks to amend the UPDF Act Cap 330 to streamline the composition of the organs and structures of the defence forces. It establishes the health care service for members of the defence forces. It establishes a medical board. It provides for the definition of service offences, the court martial, military court, and reserve force. It provides for the restructuring and establishment of the courts martial in the defence forces in accordance with Article 129(1) of the Constitution and prescribe for their jurisdiction. This bill provides for the membership and qualifications of the chairperson and the courts martial and the independence of the courts martial. It provides for appeals from the courts martial. It provides for the exceptional circumstances under which civilians may be subject to military law and prescribe the offences for which civilians may be tried by the courts martial. Right Honourable Speaker, this bill provides for the establishment of the military courts department within the defence forces. It also further provides for the establishment of a disciplinary unit within the defence forces, which shall be responsible for the discipline of the members of the defence forces. It establishes a medical board. It provides for the definition of service offences, the court martial, military court, and reserve force. It provides for the restructuring and establishment of the courts martial in the defence forces in accordance with Article 129(1) of the Constitution and
prescribed for their jurisdiction. This bill provides for the membership and qualifications of the chairperson and the courts martial and the independence of the courts martial. It provides for appeals from the courts martial. It provides for the exceptional circumstances under which civilians may be subject to military law and prescribe the offenses for which civilians may be tried by the courts martial. Right Honorable Speaker, this bill provides for the establishment of the military courts department within the defense forces. It also further provides for the establishment of a disciplinary unit within the defense forces, which shall be responsible for the discipline of the members of the military courts department. Also prescribe the arms and ammunition which are a monopoly of the defense forces and classified stores of the defense forces. It also provides for the management of the Veterans Affairs. It also repeals the Uganda Veterans Assistance Board, CAP 221, and for related matters. Right Honorable Speaker, for the record, we consulted as is demanded by the processing of the bill. We met and held discussions, constructive ones, with stakeholders, like the Ministry of Defense and Veterans Affairs. We also met the Attorney General. We held discussion with Office of the Director of Public Prosecutions. While processing this bill, Right Honorable Speaker and Honorable colleagues, we also entertained private legal, in this case, Counsel Julia Mukama. We also entertained an audience to Kampala veterans of the UPDF, who gave us enriching that amendments in clauses 29 and 30 of the bill seek to bring the Principal Act into accordance with court's ruling in the Constitutional Appeal number 2 of 2021. This, Attorney General versus Michael Kabaziguruka, which included several observations, recommendations, and other regarding individuals governed by military law. Following consultations with various stakeholders on the bill, the committee encountered diverse opinions on the Supreme Court's orders, effects, and recommendations regarding civilians under military. Under military law and the court-martialing of civilians. Clause 29 revises Section 119 of the Principal Act to clarify who falls under military law. The amended Section 117 stipulates that all defense forces members are governed by military law. Meanwhile, Clause 30 introduces a new Section 117A detailing additional individuals who may be governed by military law. This section specifies persons not part of the defense forces that may be subject to military law under exceptional circumstances. From the above, the provisions indicate two categories of individuals under military law: a member of defense forces and a civilian involved in activities outlined in Section 117A. The committee notes that amendments in clauses 29 and 30 of the bill seek to bring the Principal Act into accordance with court's ruling in the Constitutional Appeal number 2 of 2021. This, Attorney General versus Michael Kabaziguruka. which included several observations, recommendations, and other regarding individuals governed by military law. Following consultations with various stakeholders on the bill, the committee encountered diverse opinions on the Supreme Court's orders, effects, and recommendations regarding civilians under military law. Some witnesses objected to trying civilians in military courts, arguing that Supreme Court's interpretation prohibits such actions. In contrast, other committee members and stakeholders, including the learned Attorney General and the Minister of Defense, contend that the Supreme Court did not fully ban civilian trials in military courts, suggesting instead that such a trials could occur under exceptional circumstances. The committee has examined this matter and concludes that the trial of civilians by military courts should occur only in exceptional circumstances, ensuring that a fair trial is guaranteed. The committee acknowledges that military laws apply to officers and personnel within the defense forces, but they also address elements of national security. As a result, civilians can engage in actions that usually impact national security, which are typically reserved for those under military law. The reasoning for establishing offenses in the UPDF Act that hold civilian criminally liable is to safeguard national security. The committee reviewed the exceptional circumstances outlined in the bill and determined that certain aspects require revision to align with the legality principle. Specifically, the committee identifies that paragraph D, which allows the trial of civilians in military courts for aiding and abetting individuals subject to military law in committing serious crimes such as murder, aggravated robbery, intent to murder, kidnapping, treason, misprision of treason, or cattle rustling need adjustment since it fails to specify the elements of these offenses. This omission compromises the legality principle defined in Article 28(12) of the Constitution. Furthermore, the committee observes that while civilians are penalized for aiding and abetting these crimes, primary offenders face no penalties. The committee supports the proposal for trying civilians in exceptional circumstances, provided that amendments to the UPDF Act ensure a fair trial. This requires changes to the military court structure to ensure that those presiding over these trials have legal training and appointed through a transparent process, a function independently of their superiors' influence. The committee, therefore, recommends that clauses 29 and 30 form part of the bill, albeit with amendments as proposed. 6.12, restructuring of courts martial in alignment with the Constitution, particularly Article 129(1)(d). Right Honourable Speaker and Honourable colleagues, the proposed restructuring of the military courts as outlined in the bill aims to align the unit court-martial, division court-martial, and the general court-martial with the Constitution under Article 129(1)(d) of the Constitution. It introduces provisions on the qualifications, appointments, tenure, and jurisdiction for the service offenses. Additionally, the bill establishes military courts department to oversee justice administration within the defense forces. However, the committee noted that the roles and functions of the military courts department are vague, leaving gaps in oversight and accountability intended to oversee military courts. The structure risks undermining judicial independence. The military courts department includes the head general court martial as chair, along with military prosecutors, defense counsel, and chairpersons of the military courts. This overlap of judicial and prosecutorial roles is seen as a violation of natural justice principles. It threatens the right to a fair hearing by compromising impartiality of the court. Additionally, a key concern arises from the provision allowing the Chief of Defense Forces
of appointment. The committee argues that the Judicial Service Commission should be given a stronger role to vet presiding officers who wield judicial power. The committee contends that military courts must be governed by judicial oath and legal principles. We therefore recommend that persons presiding over military courts should be appointed by the Commander-in-Chief on the recommendations of Judicial Service Commission from the list generated by the High Command. Tenure of service. The bill allows a 3-year renewable tenure for chairpersons of court-martial, but is silent on the terms of other members. The committee noted that secure tenure is vital for judicial independence, safeguarding judicial officers from arbitrary removal of political pressure. A 3-year term is inadequate, and unclear removal grounds for members create insecurity, risking impartiality. Citing Justice Asaph Ruhinda-Ntenje and another versus Attorney General, Constitutional Petition number 33 of 2016, which declared fixed term contracts for 5 years for all members and the defining grounds for removal to protect judicial independence. The committee recommends that a term of all members be increased from 3 years to 5 years and is eligible for reappointment. 2, that the term should apply to all members of the courts martial and not limited to the chairperson as proposed in the bill. Appeals from decisions of courts martial. The bill permits unit court martial to the division courts martial to the general courts martial, and from the general court martial to the Court of Appeal, with the Supreme Court as the final appellate court. The Attorney General explained that since the High Court lacks appellate jurisdiction over capital offences, appeals for such cases must lay directly to the Court of Appeal. The committee agreed with this reasoning, but raised concerns about the practicability of requiring officers and soldiers in remote areas to travel to Kampala for the General Court Martial appeals. This could be costly and could hinder access to justice. Additionally, the right to appeal where the aggrieved party is dissatisfied with the unit court-martial decision has only right to appeals. While a division court-martial decision can be appealed to the Supreme Court where viewed as unfair. The bill restricts appeals on legal matters, making decisions of the chairperson of the unit and the division court-martial final. The committee deems this untenable as it prevents parties from challenging potentially erroneous legal decisions, risking miscarriages of justice. The bill's clauses on the appeal and enforcement of sentences, particularly regarding the death penalty, were also problematic. The phrase of notice of intention to appeal differs from a formal notice of appeal, creating ambiguity and risk that death sentences could be executed before appeals are determined, violating Article 22(1) of the Constitution. This article guarantees that no person shall be deprived of life except after a fair trial and confirmation by the highest appellate court. We therefore recommend, Right Honourable Speaker and Honourable colleagues, we recommend the following. 1, that appeals from the unit court-martials should lay with the division court-martial. 2, the
the decisions of a unit or division court-martial on matters of law and facts should be open to challenge. That appeals from decisions of the General Court-Martial should lay with the Court of Appeal as proposed in the bill. 4. Proposed Section 2272 should be deleted and Section 2273 be aligned with the provisions of Article 221 of the Constitution. Structural reorganization of defense forces. The committee acknowledges vital role of Uganda People's Defense Forces that has played in upholding national security and preserving and defending sovereignty and territorial integrity of Uganda. In light of the evolving security threats and expanding military responsibilities, there is a critical need to realign the UPDF structure. Structural reform is based on Uganda's legal framework, specifically Article 2010 of the Constitution that empowers Parliament to make laws regulating Uganda People's Defense Forces, and in particular provide for the organs and structures of UPDF. Section 2 of the UPDF Act Cap 330 provide for the mandate of Parliament to make laws, prescribe any services beside the land and air forces. At present, these two branches are central to the military operations of the UPDF, which also receives assistance from the reserve force during emergency. Act Cap 330 provide for the mandate of Parliament to make laws, prescribe any services beside the land and air forces. At present, these two branches are central to the military operations of the UPDF, which also receives assistance from the reserve force during emergencies. A significant advancement has been the emergence of Special Forces Command, a specialized allied unit tasked with carrying out specialized missions or operations at the moment notice, very important persons, protection and reconnaissance. While it is not legally provided for as a distinct service, the SFC provisions for retirement benefits, gratuity, and pensions, including entitlements related to death in service and disability, ensuring improved welfare and dignity for the serving personnel and the veterans alike. The Kampala reduction in force UPDF veterans informed the committee that although they voluntarily enlisted in the National Resistance Army struggle,
which ultimately resulted in a change of government. They continued to serve in the NRA UPDF until their discharge, which occurred without a proper and formal dismissal. The committee notes that the UPDF has transformed since the 1990s, following significant military downsizing after achieving stability post-internal conflict. This began demobilization efforts, and restructuring of the UPDF alongside pension reforms for veterans. The reduction in force affected thousands of personnel, especially older veterans and non-combatants, aimed at enhancing security and lowering public spending. However, systemic issues in the pension system emerged as many veterans faced unclear entitlements, delays, and bureaucratic hurdles in obtaining their benefits. Scholars such as Obore in 2006 highlight that while legislation aimed to guarantee pension rights, many veterans remain unrecognized due to inadequate documentation or unclear classifications, e.g. informal service or voluntarism, not recognized as pensionable. Thus, the committee believes that while the bill will strengthen the pension and gratuity administration for the UPDF veterans, actual realization of the rights remains uneven for the demobilized veterans. Additionally, the bill currently excludes individuals or militants who retired before its enactment, which lacks a commencement date. Its provisions have no retrospective effect and do not address retired officers and militants. Right Honorable Speaker and Honorable colleagues, we therefore recommend, 1, that the decentralization of the pension authority to the Ministry of Defense and Veteran Affairs as proposed in the bill should be adopted to enhance efficiency, transparency, and responsiveness in addressing pension-related issues for military personnel and veterans alike. Welfare and health services. The committee observes that the bill proposes establishing a health care service.
Madam Speaker, I'm rising on point of order. Earlier you had ruled that this front bench be reserved. As it is now, the several members appear to be part of my team, but when I invite them to support me, they shy away. Is it in order that they sit here when, is it in order for them to continue defying the ruling that you made, that this front seat be reserved for the members? Is it in order?
Honorable Wilson, continue.
Thank you. Right Honorable Speaker, I am now addressing committee's concerns and observations on welfare and health services. The committee observes that the bill proposes establishing a health care service for the Defense Forces personnel, creating a dedicated health care service for the military personnel,
listen to the
introduces, Right Honorable Speaker, creating a dedicated health care service for the military personnel introduces extensive health care system, including routine medical care for the dependents of the officers and militants, rehabilitation services, and access to specialized treatments abroad when necessary. Additionally, the Defense Forces Medical Board has been established to manage medical evacuations, to manage medical evaluations, conduct disability assessments, and approve treatment for officers and militants. These reforms are designed to ensure that all military personnel receive timely, effective, and specialized health care during their service and after their service. The committee opines that a dedicated health care service for the defense personnel, separate from civilian, addresses a unique nature of military service requiring specialized, timely, and continuous medical support tailored to risks faced by the defense forces. Military personnel often need rapid access to trauma care, rehabilitation for service-related injuries, and treatment for psychological conditions from combat or deployment. The Defense Forces Medical Board will ensure medical evaluations, disability assessments, and treatment decisions aligned with the military standards and readiness, which civilians' health care may not adequately address. The Joint Committee therefore recommends that 1. Establishment and operationalization of a dedicated healthcare service for the defense personnel, as opposed in the bill, be fully supported and adequately resourced to ensure the delivery of specialized, timely, mission-specific medical care, addressing the unique medical and psychological and rehabilitative needs of the military personnel. Monopoly and security classifications. The bill introduces measures to strengthen monopoly and security classification concerning crucial military assets of the UPDF. It specifically outlines which arms and ammunition are solely under the control of defense forces, guaranteeing that these materials remain inaccessible to unauthorized parties. Additionally, the identification and safeguarding of classified equipment and materials will now be regarded as sensitive to national security and will be strictly regulated according to military protocols. These reforms, Right Honorable Speaker and Honorable colleagues, aim to bolster national security, prevent unauthorized access, and uphold operational integrity by ensuring that only designated military officials oversee and protect these assets. However, the committee observes that the classification and the categorization of materials under the exclusive control of the defense forces, particularly military uniforms, can have significant implications for civilian wear. When clothing that closely resembles military colors, patterns, or designs are classified as military property, civilians wearing similar attire or clothing may face restrictions or even legal consequences. This is specifically in context where the resemblance is coincidental or fashion-based rather than intended to personate military personnel. For instance, in the bill under Clause 82, Schedule 7B, several uniforms for ceremonial wear, including ordinary black shoes, kaunda suits in the coffee brown, blue, and khaki, have been categorized as exclusive wear for the defense forces. Yet, these are very colors of clothing and black shoes are seen as ordinary wear by the public. Be that as it may, the committee asserts that civilians wearing military-style attire and berets, even without official insignia, significantly risks military identity, public trust, and operational scrutiny. Such apparel can confuse the public, undermine military distinctiveness, and grant an earned authority to those not following military codes. In operational or emergency situations, the difficulty in distinguishing trained service members from similarly attired civilians may compromise coordination and increase risks, potentially damaging the armed forces' professional image. Recommendations. We therefore recommend that Schedule 7B should be amended to include a requirement for marking military stores with the logos and insignia of the UPDF, thereby distinguishing them from civilian items. 2, that the provision should be inserted to restrict the wearing of camouflage military-style uniforms and berets by individuals who are not part of the military. Conclusion, Right Honorable Speaker and honorable colleagues, we therefore recommend that the bill be considered for the second reading, subject to the proposed amendments attached here to and any other modifications the House may propose and approve. Right Honorable Speaker and Honorable colleagues, I beg to report.
Thank you. Thank you so much. Thank you. As you informed that we have a minority report from Junior, Okotish Moses Junior. Please present your report. Go to areas of dissent.
I'm not bespoking.
Habib, you extend, you're disturbing Junior.
The Right Honourable Speaker and members, I move to present the minority report, but prior to the presentation, I intend to make an opening statement. In arriving at this report, we, the members of the joint committees of Defense and Parliamentary Legal Affairs, did in a higgledy-piggledy manner haphazardly reached a position that would qualify the report that I am reading to be the majority report. And to justify the same, we had about 14 members signing this report out of the total number of members of these two committees.
How many members signed the majority report? Let's get a difference between majority and minority.
Right Honorable Speaker, the majority report has been signed by a total number of 26 members.
The joint, yes, then the joint 14 decide, okay.
While I finish making my submission prior to reading to this report, is that I want to urge the members that if reason, persuasion, logic, and science has never taken the day in this House, let it take today, because this is a very critical part of the bill that I decided out of the opposition to remain in this House so that I present logic, science, reason, and law to the House.
There's an order.
Thank you very much, Right Honourable Speaker. I rise on a point of order. This House is constituted of distinguished ladies and gentlemen representing this country, and we've been handling business since the beginning of this term. Is it in order for my friend to say we are illogical, that we have never applied logic in this House, and it is only him who is illogical in this House? When we represent our different constituencies, is in order to demean and insult us as members of this House?
Thank you. The members of this House reason with reason and with the logic, and these are honourable members of Parliament. So whenever there is a debate here, it is done with the logic and reason. So we cannot have a House belittled to that level. So Junior, withdraw your statement. Junior.
Rightfully so, Right Honourable Speaker, I withdraw.
Honourable members, allow me to chair the House. Junior has withdrawn the statement, and it will be expunged from the Hansard. Because the members that we have here are members of logic and reason, and they are honourable members of Parliament. Yes, Junior.
Right,
You
Honorable
go and
Speaker.
look for them.
Right, Honorable Speaker.
Junior, continue.
Right, Honorable Speaker, if the House may please, I'll read.
Read your report.
Right, Honorable Speaker and colleagues, this is the statement of the minority members of the Joint Committee of Legal and Parliamentary Affairs, Committee of Defense and Internal Affairs on the decision of the majority in respect of Uganda People's Defense Force Amendment Bill 2025, herein referred as the UPDF Amendment Bill. This statement is made pursuant to Rules 214 and 215 of the Rules of Procedure of Parliament of Uganda. The UPDF Amendment Bill 2025 was read for the first time on Tuesday, 13th of May 2025, and in accordance with the Rules 134 and 200 referred Joint Committee of Parliamentary Legal Affairs and that of Defense for scrutiny. The object of the bill is to amend the Uganda People's Defense Force Act Cap 330 to majorly give effect to the decision of the Supreme Court in Constitutional Appeal number 2 of 2021, Attorney General versus Honorable Michael Kabazaruka, among others. Pardon, members, I am born, raised, nurtured of a Luo descent, and there are certain syntaxes that may not appear.
Go ahead, Honorable Kabazaruka.
The decision of the Supreme Court in the Constitutional Appeal number 2 of 2021, Attorney General versus Michael Kabazaruka, is well detailed and uploaded. I am going straight to read the point of dissent to allow members probably. Point of dissent is on 330. And this is the substance of our submission. Our dissent from the majority is guided by Article 9 by the 1995 Constitution of the Republic of Uganda and the Supreme Court judgment in Attorney General versus Michael Kabazaruka, Constitutional Appeal number 2 of 2021, arising from Constitutional Petition number 45 of 2016. As a locus classicus case, in addition to other authorities, the point of dissent are: 1. Contravention of the Constitution. 2. Illegality in military trial. 3. Offending the doctrine of separation of power. 4. Lack of public participation. 5. Unconstitutional expansion of the military court's jurisdiction. 6. Constitutional limitation on Parliament's power. 7. Lack of independence and impartiality of the court-martial. 8. Non-compliance with the judicial advisory order of the Supreme Court ruling. Members and Right Honorable Speaker, on issues of contravention of the Constitution, Article 92 of the Constitution provides a restriction on retrospective legislation. Parliament shall not, if I may, Parliament shall not pass any law to alter the decision or judgment of any court between parties to a decision or judgment. The above provides a bar on legislative powers of Parliament in enacting any law that has effect of overturning or altering the decision or the judgment of court. Clause 30 of the bill proposes to introduce a new section, that is section 117A in the UPDF Act, to provide for other persons who are subject to military law. The provision requires that a person other than a member of the defense force shall be subject to military law under the following exceptional circumstances: where a person voluntarily accompanies any unit or element of the UPDF of the Defense Force which is in active service in any place. B, where while serving in Defense Force under the engagement by which he or she has agreed to be subject to military law. C, where the person is in unlawful possession of arms, ammunition, equipment, ordinarily being a monopoly of the Defense Force, prescribed in Schedule 7A of this Act, or classified as stores prescribed in Schedule 7B to this Act, commits an offense under any written law. D, where the person aids or abets a person subject to military law in the commission or conspires with a person subject to military law to commit the offenses. The offenses below: 1, murder; 2, aggravated robbery; 3, kidnap with intent to murder; treason, misprision of treason, or cattle rustling. E, where the person without authority is found in possession of or sells or wears a uniform of the Defense Forces, or where the person is found in unlawful possession of arms, ammunition, or equipment ordinarily belonging to the monopoly of the Defense Force, prescribed in Schedule 7A of this Act, or classified stores as prescribed in Schedule 7B of this Act. G, where a person is serving in position of an officer or a militant of any force raised and maintained outside Uganda and accompanied by the officer of the Defense Force. The above clause is an attempt to reenact Section 117 of the UPDF Act, which was struck down by the Supreme Court for offending Article 28(1), 44C, 128(1) of the Constitution. Such is inimical to the rule of law, good governance, which is a cornerstone of democratic dispersion, and that of other civilized nations and communities across the globe. It also constitutes an egregious attack on judicial independence, thereby contradicting Article 28(2) and 3 of the Constitution, which provides that no person or authority shall interfere with the courts or judicial officers in the exercise of judicial functions, and that all organs and agencies of the state shall accord to the courts such assistance as may be required to ensure effectiveness of the courts. See Article 28(2) and 3 of the Constitution. This action amounts to contempt of the Supreme Court, which is criminal, a path that must be avoided by a decent parliament. Right Honourable Speaker, in a locus classicus case...
Do you have to ask to add a decent parliament? Must you add decent? Nobody doubts that we are decent.
Avoided by our parliament.
So
most obliged.
Expand the word decent.
In the locus classicus case of Liange versus the Queen, 1967, the Sri Lanka Parliament passed a retrospective law affecting the trial of individual accused of attempted coup. The Privy Council struck down the law on account that it sought to alter the course of a particular decision and effectively overturned the jurisdiction. The Indian Supreme Court in Indira Nehru Gandhi versus Raja Nara in 1975, SC 2299, after election was invalidated by the High Court constitutional amendment that was passed to validate the election. The Supreme Court struck the amendment, holding that the Parliament cannot enact legislation that overturns specific judicial decisions. Any legislation passed with the object of annulling the effect of a judicial decision has been held to be an encroachment on the judicial powers and it is unconstitutional. Your Honor, coming down there were other authorities that, Right Honorable Speaker and colleagues, there were other authorities that were cited year after to persuade the House. I had members to peruse through while I go to deal with the second area of dissent. The second area of dissent is illegality in military trials. Your Honor, Right Honorable Speaker, the question of illegality in military trial is ably canvassed by the Supreme Court in the case of Michael Kabaziruka in the above case. Owindolo CJ, in his lead judgment at page 180 and to 185, had this to say, Your Right Honorable Speaker. There are also other vital reasons militating against trials of persons subject to military law for all offenses. These courts has previously held that there are certain offenses that are not triable by the court-martial. This is so where a particular act grants jurisdiction under it only to a specific court. It would therefore be wrong for Parliament to cause a conflict by conferring on court-martial jurisdiction to try such offences. For instance, since terrorism can only be tried by the High Court, which is an ordinarily civil court.
Honorable Court Junior.
Yes, Your Honor.
Honorable Justice, Chief Justice Owejidolo had this to say. Open court, and then you close the court. Somebody will imagine
Most obliged.
that it continues up to the end.
Most obliged.
Close the court first.
Speaker. And if I may proceed from where I had stopped, Right Honorable Speaker.
For clarity, say what Chief Justice said, open court, close it, then you bring your statement.
Right Honorable Speaker, the CJ, Justice Owindolo, in his lead judgment at page 180 to 185, had this to say. Open court. There are also other vital reasons militating against trials of persons subject to military law for all offenses. This court has previously held that there are certain offenses that are not triable by the court-martial. This is so where a particular act grants jurisdiction under it only to a specific court. It would therefore be wrong for Parliament to cause a conflict by conferring on a court-martial jurisdiction to try such an offense. For instance, since terrorism can only be tried by High Court, which is an ordinary or civil court, it would be contradictory to try it in the military court as well. And also it would be self-defeating for an offense similar to terrorism to be created under the UPDF Act and then the persons are tried under it, close quote. I find this holding by Mulenga by Justice of the Supreme Court, Justice Mulenga, still correct position of the law, and where jurisdiction is expressly excluded or where the DPP's consent is a prerequisite, the court martial are not competent to handle that matter, so excluded, irrespective of the provision to the contrary. Under the impugned section 117 and 117I, G and H of the UPDF Act, it amounts to duplication to grant jurisdiction to the court martial over it when, owing to the gravity of these offenses, Parliament conferred jurisdiction over them to ordinary courts. The other issue for consideration is the danger possessed by concurrent jurisdiction, where the military courts could try a case that is also before an ordinary court. This would necessitate the establishment of a mechanism between the court-martial and the DPP to manage the cases, beyond mere provisions in the UPDF Act, and the jurisdiction of the court-martial does not take away that of the civil courts. Concurrent trials in both military and ordinary courts for civil offenses would also be prejudicial to an accused, for a simple reason that it could lead to double jeopardy, as each court could potentially come up with a guilty verdict. Additionally, as already noted, the General Court Martial and other military courts are subordinate courts. See, in the case of Attorney General versus Uganda Law Society, Constitutional Appeal number 1 of 2006. However, I do not agree with Justice Mulenga's finding, where he held that the General Court Martial is subordinate but not lower than the Court Martial. According to the Black Laws Dictionary, Brian A. Garner, 8th edition, subordinate means placed in or belonging to a lower rank or class or position, or subject to another authority or control. Assigning an ordinary meaning to the word subordinate, all court martials as subordinate courts created under Article 129 1D can only have jurisdiction that is lower than the High Court. Saying that it is subordinate but not lower than that of the High Court is contradictory and has the potential to create an absurdity when it comes to hearing of capital offenses. If Parliament desires to grant them the jurisdiction to handle capital cases, then it would need to do so in line with the Constitution. I will return to this later in advisory opinion to explore the options that could be undertaken by Parliament to achieve this effect constitutionally. With this finding, the hearing by all court martials of offences within the jurisdiction of the court martial is unconstitutional under Article 28(1), 44(c), 128(1), 129(d). Close quote. The general rule is that ordinary courts alone have jurisdiction to try civilians. The Supreme Court was unable to find any rational justifiable link between the need to maintain discipline in the army or maintenance of security of Ugandan borders and trials of civilians in the military court tribunals generally. However, having held as above, the Chief Justice made the following orders. A. The provisions of 179 1, 2, and now 171 1 and 2 of the UPDF Act.
Is it 171 or 177 1 and 2?
179, 1, and then 1 and 2, and then 177, 1 and 2 of the UPDF Act. Read together with 197.2 and now 197.2, which grants subordinate military courts jurisdiction over capital offences, contravenes Article 129, 1D and Article 126, 1 of the Constitution. Hence, they are unconstitutional. The provisions of Section 119, 1I and G, now 117(1) and G is unconstitutional to the extent that it permits trials in court-martials of civilians who allegedly aided and abetted the commission of service offences or ordinary criminal offences in which a person subject to military law is a principal offender. Right Honourable Speaker, the minority observes, I'll jump D, the minority observes that the Supreme Court's decision had the following effects. The trial of civilians by court is only permissible in exceptional circumstances and only after state has concretely demonstrated to court by verifiable facts and by objective and serious reasons, need and justification for a recourse to a military court. 2, the minority observed that military courts can only have jurisdiction in relation to specific class or category of persons and specific offences which ordinary courts are not in position to try. 3, the jurisdiction of the court-martial can only extend to cases reserved for specialized courts such as Anti-Corruption Court under the Anti-Corruption Act, International Crimes Division under the Anti-Terrorism Act. 4, military courts cannot have jurisdiction of offences which require the consent of the DPP. The consent of the DPP. 5, civilians cannot commit or be tried for service offences even when they abet or aid the commission of offences. 6, where civilian and military personnel have committed a crime other than a service offence, both be tried in civil courts. In 7, Parliament cannot duplicate offences prescribed in other acts of Parliament to introduce them in the UPDF Act. Colleagues, members of Parliament, the ratio from the above, with a sober appreciation of the provisions of Article 28 of the Constitution, leads to inevitable and incontrovertible conclusion that all persons, militant or otherwise facing criminal trials, have a right to appear before a competent, independent, fair, impartial court or a tribunal with a decision of the Supreme Court. The trial of persons with offences within the exclusive jurisdiction of the civil courts, particularly by the High Court. Military courts are not competent to try such cases. It goes, therefore, without saying that any trial will still be unconstitutional and will offend the principles of a fair trial. Accordingly, enacting the proposed legislation into law will be a legislation in vain. Common theme among justices of the Supreme Court Common themes among the justices of the Supreme Court was that the General Court Martial is a tribunal and should be kept as such. Right Honorable Speaker and members, let me conclude on this note. Court-martials should be specialized disciplinary tribunals with restrictive functions to handle disciplinary matters that are peculiar to and connected with discipline and regulations of the armed forces. By Justice Catherine Bamugemere, Justice of the Supreme Court, at page 41 of our judgment. Colleagues, members of Parliament, having appreciated that the second area of dissent has been appreciated, I would go to
the third area of dissent.
Your Honor, Right Honorable Speaker, offending the doctrine of separation of powers. Modern democracies are typically organized around three branches of government, each playing a crucial and distinctive role. Adjudication in particular is a function and a preserve of the judicial branch of government. Overriding or intrusion would in any of the other two would inevitably offend the Constitution. The judgment of the Supreme Court covers situations where military under the UPDF Act may depart from this position by only in a very exceptional circumstance that are consistent with demonstrable justification. The Chief Justice at page 78 to 79, quoting Nalwero in his work, Improving the Administration of Justice by Military Court in Africa, an appraisal of the jurisprudence on human and people's rights, 2019. Held that a host of authorities, held that separations of power helps to provide sufficient safeguard to ensure fair hearing by instruments enunciated by the law on independence and impartiality of the court-martial, such as cardinal and core to the administration of justice. The minority are of the view that granting the military, through court-martial, the unlimited power to try persons with offenses beyond disciplinary ones would be a violation to the doctrine of separation of power, beyond its function envisaged in Article 209 of the Constitution. Article 210 of the Constitution, pursuant to which the UPDF was enacted, did not envisage the establishment of a military and judicial function. Such an extension, therefore, can only be handwork of a overzealous but mischievous stretch imagination, rooted, brewed, and bred in imperfection by proposing an amendment which doesn't meet the test of legitimacy, and we invite Parliament to reject this bill to this extent. 3-0, impartiality and independence of the courts. Right Honorable Speaker and colleagues, members of Parliament, the impartiality and independence are not decorative ideals. They are constitutional imperatives grounded on Article 28 of the Constitution, the right to a fair hearing, and Article 128 of the Constitution, independence of the judiciary, military courts as a creature of statutes are subordinate to the constitutional principles and are bound by these standards. Article 128(1) of the Constitution also imposes a requirement as to the objective of the independence of the courts or tribunals, exercising judicial powers as a safeguard to a fair hearing. It states that in the exercise of judicial powers, the courts shall be independent and shall not be subject to the control or direction of any person or authority. The bill in clauses 35, 36, 38, and 45 provides for various amendments to the UPDF Act, specifically to the provisions establishing courts martial. It creates the following court martials: a unit court martial, divisions court martial, the general court martial. The bill removes the following courts and trial processes: A, the commanding officer or officer commanding; 2B, trial by superior authority; C, court martial, court of appeal; D, field court martial; E, summary trial. Despite the aforementioned, the bill did not respond to the orders and recommendations of the Constitutional Appeal number 2 of 2021, Attorney General versus Michael Kabazaruka, as far as independence and impartiality is concerned. Colleagues, I am persuaded to take you further to our next point of dissent, appreciating that you have read what we are talking about. Colleagues, I have seen the labor you've had to listen to these submissions because it is aided by legal gymnastics and quoting of cases. But please listen. Let me go to recommendations. Recommendations. The minority finds that the provisions of clauses 30 specifically proposes Section 117A. Proposed Section 117A is unconstitutional, irregular, and illegal as far as it allows the trial of civilians by military courts in the circumstances that are not exceptional. B, it extends to the jurisdiction of military courts. It extends the jurisdiction of military courts to the entire civilian population and to all offenses which ordinary courts are in position to try. C, the bill also extends military courts to cases reserved for specialized courts such as the High Court. D, the bill extends service offenses to civilians. Minority cautions Parliament that the Supreme Court directed Parliament not to duplicate offenses prescribed in other acts of Parliament and introduce them in the UPDF Act, where therefore recommend that the same be rejected. 4.0, lack of public participation. The Constitution in Article 38(1) and 2 thereof reaffirms the right of every citizen to participate in the affairs of government in accordance with the law. This includes engaging peaceful activities to influence the policy of government. On Tuesday, 13th of May, the Clerk of Parliament issued notice inviting the public to submit their views to Parliament by or before the 14th day of May 2025. It is clear that by the time of issuing the notice, the bill had not been presented to Parliament in the plenary, which started at 2 p.m. The requirement of public participation is rooted and entrenched in our constitutional framework and must not be cosmetic reasons. Colleagues, various stakeholders were therefore locked out of the process due to this clearly cosmetic semblance. In the view of the minority, this did not meet the required standard of public participation. Indeed, apart from the Attorney General and the sponsoring minister, the committee interacted with only two other stakeholders, that is the DPP and Council Jude Biamukama. One would wonder why a matter of great national importance of this magnitude would only attract two external stakeholders. This is unprecedented in matters of this nature. On this account, in addition to other reasons given, the minority invites Parliament to reject the bill to the extent proposed herein. This was the conclusion of the minority. Right Honourable Speaker, whereas reforms within the UPDF Act are necessary to address contemporary security challenges, such reforms must not compromise constitutional rights. Judicial independence or civilian oversight. We, the minority, persuade this Parliament to reconsider the provisions of the UPDF Amendment Bill 2025 to ensure they align to the principles of democracy, rule of law, and respect of human rights. Therefore, the minority unanimously are of the opinion that the General Court Martial and other courts do not have constitutional jurisdiction to try civilians or adjudicate non-disciplinary criminal offences, even if committed by members of the Uganda People's Defence Force under Article 210 of the 1995 Constitution. Parliament's power to legislate for military courts is strictly confined to matters of discipline and removal of the UPDF. Members, military courts are therefore internal discipline bodies, not general criminal courts, and cannot override the constitutional mandate that all criminal justice, including a fair trial right under Article 28 and 44, lies exclusively with the courts of judicature.
Thank you.
Members, this was jointly and severally the report by the minority. Back to submit.
Thank you. Thank you so much. Honourable members, there are two minority reports. Not so, Chair. There are two minority reports.
Right. Second one, I am not aware, and it offends the rules of procedure, Right Honourable Speaker.
Yes.
The Right Honourable Speaker, according to the official information we have is that the opposition are officially boycotting this sitting. I would wonder how my colleagues are masquerading here.
Honorable. Honorable members, opposition is in the house. Opposition is in the house. I see Honorable Kelo, Honorable Court, Honorable Olanya, Honorable Santa, Honorable Duru, who has ably presented a report, Honorable Namanya. Honorable members, Legal, did you get a report from?
I've just received a document. Someone came and dumped a document here, but I've just read. It is a minority report of the Honorable Jonathan Odur. I was not informed what it was, but I've just read and realized it is
The man did not attend.
After all, it's a minority. It's a minority.
Yes, Fox.
Thank you, Right Honorable Speaker. Right Honorable Speaker, I rise to move a motion.
No, there is still an issue of the minority of Honorable Dor, which the chair said was not given to him.
But, Right Honorable Speaker.
Honorable, yes, yes, Honorable Minister.
Right Honorable Speaker, since NRM believes in democracy, we should allow Honorable Dole present to the House.
Honorable Chris.
Thank you very much, Right Honorable Speaker. We make the rules ourselves as the Parliament, and we must respect our own rules. Everybody to abuse provisions of our rules. If the rules require that a member dissenting must formally process his report, give it a chair, let it be. Let's not allow abuse of our rules. And therefore, if he has not followed what the rules provide for, we should not listen to that report.
Honorable members, let's not be seen to be suffocating in a member. Let Honorable Duru come up with his report and give us a summary of his report, his areas of dissent. Let him do it.
Thank you very much, Right Honorable Speaker. Madam Speaker, for the record, this morning I made a phone call to the chairman of Legal and Parliamentary Affairs Committee, and I told him on the phone that I have a minority and the chair is here. Secondly, when I reached Parliament, I again notified him on our platform, and then I filed this report with the clerk of our committee, who duly submitted to the clerk of Parliament. It has been duly stamped as received. So the record should show that I am not smuggling, I'm just complying with the rules. Madam Speaker, before I read, I beg these two situations for members to bear with me. First of all, as Honorable Ochero rightly observed, the leader of the opposition, my boss, has led a walkout from this city, and I am his shadow minister for justice and constitutional affairs. You can imagine the situation I'll be. I may finish and I get fired. So allow me to present this report here. Secondly, in tense moments like this, you would beg that members bear with me. During the ruling in the Supreme Court at myself and many others against the Attorney General, when their lordships had judged 3 against 3, the last judgment was by the Chief Justice then, Bart Katurebe, and when he had begun to read, he informed us that his glasses and the eyes had a problem and he needed to be rushed to South Africa immediately. I pray when I'm reading this report, my glasses don't fail me. Having said that, Madam Speaker, introduction. This is a minority report in dissent of the majority report of the Joint Committee of Legal and Parliamentary Affairs and the Committee of Defense and Internal Affairs on the Uganda People's Defense Force Amendment Bill 2025. This minority report is brought under Rule 215 of the Rules of Procedure of Parliament, areas of dissent and statement of reasons for dissent. The minority restricts the areas of dissent majorly on the policy and principles, defects in the existing law, remedies proposed in the bill, and specific provisions of the Uganda People's Defense Forces Amendment Bill 2025, touching the court-martial and related matters, including the shadows approach. In this minority report, it presents specific thematic areas of dissent, the reasons for the dissent, and explanatory statements for the reasons of dissent, and this minority report is guided by the provisions of the 1995 Constitution of the Republic of Uganda, the applicable subsidiary legislations, and the lead judgment in the Supreme Case, Attorney General versus Michael A. Kabaziguruka, Constitutional Appeal number 2 of 2021. Therefore, Right Honorable Speaker, each word, sentence, paragraph in this report has been carefully considered by the minority for justifying the dissent from the main report of the committee. The minority prays that time be allowed for this report to be presented to the House, both verbatim and seriatim. Thank you. Preliminary and substantive discussions on points of law. In this report, the minority raises several points of law in both preliminary and substantive forms. The minority submits that meaningful debates and decisions of Parliament can only take place after the presiding officer has disposed of, by way of a formal ruling, with reasons, all the points of law raised. The presiding officer should not be tempted to sweep under the carpet, fail, or casually dismiss these important issues of points of law raised by the minority. In short, the minority invites the full attention of the presiding officer during the presentation of this report and prays for the rulings to be delivered on record in a timely manner before debate ensues. Breach of Rule 75 of the Rules of Procedure of Parliament on Sub Judice. During the consideration of the bill, the Uganda Law Society brought to the attention of the committee and Parliament an active court case in the East African Court of Justice, which court decisions are binding on Uganda as set out in the landmark precedent case of Among A. Anita versus Attorney General of Uganda, and another, reference number 6 of 2012. I produced the letter dated 14th May 2025, and it is addressed to the clerk to Parliament and reads as follows. Reference, the Uganda People's Defense Amendment Bill 2025. Greetings from the Council, Management, and staff of Uganda Law Society. In response to your invitation to meet the Joint Committee on Defense and Internal Affairs and Legal and Parliamentary Affairs for consideration of the above captioned bill, for which we are grateful, this is to inform the Joint Committee as follows. 1. The Uganda Law Society received your invitation letter today at 11:50 a.m., scheduling a meeting for 12 p.m. on the same day. With the greatest respect, the time frame is manifestly inadequate for a thorough consideration of the 150-page bill and is incompatible with democratic accountability. 2. Be that as it may, the Uganda Law Society hereby brings to your attention reference number 14 of 2025, Uganda Law Society versus the Attorney General of the Republic of Uganda, pending before the East African Court of Justice, discussing the bill's provision on military courts would inevitably breach the sub judice rule, contrary to Rule 75 of the Rules of Procedure of Parliament of Uganda, Statutory Instrument Number 43 of 2025, and Article 38, Sub-Article 2 of the Treaty for Establishment of the East African Community, and potentially contravenes Articles 2, 20, 79.3, 92, 126.1, 128.3, and 287 of the Constitution of the Republic of Uganda. 3. Given the pending litigation, we respectfully request the Joint Committee to urge government to pursue amicable resolution of the dispute before engaging Parliament and on the contested matters. The Uganda Law Society welcomes the opportunity of another invitation to discuss the rest of the bill. Yours, it is signed by Ewan Asimwe Anthony, who is the Vice President of Uganda Law Society. I don't know for what reason why the President was not available to sign. I now beg to lay on table the copy of duly received by the Office of the Clerk, as well as a copy of the reference number 14 of 2025 Uganda Law Society versus the Attorney General of the Republic of Uganda. Madam Speaker, this document is already part of the minutes laid by the committee. If it is not there, I have a copy that I can lay. In the same vein, the minority also draws to the attention of the Right Honorable Speaker of Parliament and Parliament the constitutional application number 01 of 2025, Male Mabirizi K. Kiwanoka versus the Attorney General, filed in the Supreme Court of Uganda on 14 April 2025. And the same has been duly served upon the respondent who is present in this sitting. The gist of that application is that the Supreme Court should determine whether the action of the respondent, who is the Attorney General and Government and Parliament, of proposing and consideration of the Uganda People's Defense Forces Amendment Bill 2025, providing for trials of civilians in the court-martial, is contemptuous of the judgment of the Supreme Court in Uganda, in Supreme Court of Uganda in Attorney General versus Michael, which I have already cited fully. The constitutional application number 01 of 2025, as referred, filed in the Supreme Court, has already been duly served. The respondent, the Attorney General, is present in this House and can confirm or deny the existence of this live case. All that the minority is belaboring by this submission is to demonstrate by all standards that there is a live and active dispute, not only before the East African Court of Justice, but also Uganda's highest court, the Supreme Court. It will be quite embarrassing for Parliament, an institution central to democracy and the rule of law, to carry on with the consideration of the Uganda People's Defense Forces Amendment Bill 2025, well aware of the court cases that touch on the subject matter of the clauses in the bill. The finding of the minority. The minority finds that Parliament proceeding to consider the clauses of the UPDF Amendment Bill 2025 touching the subject matter of trial of civilians in the court-martial undermines the core tenets of the rule of law, the doctrine of mutual respect for separation of powers between the executive, legislature, and judiciary. The next is on retrospectivity of legislation, contrary to Article 92 of the Constitution of Uganda. Article 92 of the Constitution of the Republic of Uganda on restriction on retrospective legislation states as follows: Parliament shall not pass any law to alter the decisions or judgments of any court as between the parties to the decision or judgment. Decisions or judgments of courts are categorized into two: one in personam and two in rem, to mean against a person and the world at large. In the considered opinion of the minority, that judgment in Constitutional Appeal number 2 of 2021, Attorney General versus Michael K. is firmly binding on the movers of the bill as well as this Parliament. In short, unless Parliament is deliberately and without utmost and with utmost impunity, dismissive of the judgment of the Supreme Court of Uganda, which judgment was led by none other than Honorable the Chief Justice of Uganda, Alphonse C. Owindolo, together with his brother and sister lordships of the Supreme Court, the Honorable Lady Justice Catherine Bamugemereze, the Honorable Lady Justice Monica Kalejera Mugenyi, the Honorable Lady Justice Faith Mwanda, the Honorable Lady Justice Elizabeth Musoke, the Honorable Lady Justice Percy Knight Tuhaise, and the Honorable Justice Mike J. Chibita, who did an splendid job. And I invite members who are still active that when you get children, you can name them after these lordships. And those who cannot get children, when the technology-assisted reproductive law comes in force, you can produce using and name them. One of the best indicators of a progressive democracy is respect for the rule of law, which includes respect for judgments of courts. If this parliament, in the full glare of right-thinking Ugandans and the entire world, proceeds to disobey the Supreme Court, then this date and year will go down as the official birthday of the dreaded military dictatorship in Uganda. We surely don't wish to be the midwives to deliver this baby at all. Madam Speaker, let it also sink in our minds that at any one point soon in our lifetime, Uganda will have another president other than H.E. Museveni. The next president, as per the law, shall be the commander-in-chief, boss of the court-martial. This House may have already noticed the following names, in no particular order of chances of being the president, being discussed in the public domain as potential future presidents starting in 2026 and beyond. The Honorable Akena Jimmy James Michael Obote, the Honorable Chagulanyi Sentamu Robert, the Honorable Amuriat Patrick Oboy, General Kaino Rugaba Muhozi, General Mugisha Muntu, Honorable Norbert Mao, Right Honorable Aneta Mao, Colonel retired Dr. Kiza Warren Besige.
Honorable, I have never wished to be a president. Remove my name from that list. I am satisfied with what I have, and I'm even getting out of politics. Don't put my name into this.
Madam Speaker.
No, my name is not for playing. My name is not for jokes.
Madam Speaker, allow me, since it's a one.
Please, my name is not for jokes. I never want.
Yes,
Honorable, it is my name.
Madam,
please remove it.
Yes, this is a one member's report signed by me, and I can amend it. I want to withdraw. That's what the point I want to
make. Withdraw. I'm not part of that.
That although I had said that the names were in the public domain,
public domain.
I beg to withdraw.
I have my own right.
I beg to withdraw and delete and amend this report by deleting the name Right Honorable Anita Among Annette from this report. And I accordingly withdraw and apologize to you, Madam Speaker. Please, the record has it. Please, I invite this House to carefully reflect on each one of them, their soberness, fidelity to the law, ideologies, actions, sentiments, service records, and imagine what each one of them is capable of using such provisions in the bill. The finding. The minority finds that legislating on clauses of the bill that touch on the decision of the Supreme Court, specifically enacting clauses to try civilians and soldiers who commit civilian crimes in the court-martial, contravenes Article 92 of the Constitution of the Republic of Uganda in light of the case of the Attorney General versus Michael K. Constitutional Appeal number 2 of 2021. The next point is decent is understanding of the judgment of the Supreme Court in that case. Right Honorable Speaker, during the consideration of the bill in the committee, an issue arose as to whether there was a lead judgment to inform the consideration of the bill, or all judgments of the quorum mattered. The learned Attorney General informed the committee that the judgment of Honorable the Chief Justice, as is the lead judgment, whose final orders and recommendations guided the drafting of the bill. Whereas the minority considered the other judgments as equally important, in as far as several rulings therein, the minority, for purpose of harmony, agreed with the Attorney General to restrict discussions around the lead judgment of Honorable the Chief Justice Alphonse C. Owindolo, who listed 6 specific issues that the Supreme Court was required to resolve, and the issues are as follows. The first was whether the court-martial are courts established under the Constitution or are mere tribunals. 2, whether the court-martial can be or are independent and impartial within the meaning of Article 28 of the Constitution. Whether civilians can legally be liable to face trial in the court-martial for disciplinary offenses herein called military, disciplinary, or service offenses stipulated in Part 6 of the UPDF Act. 4, whether civilians can constitutionally or legally be tried in the courts-martial for civil offenses not comprised in Part 6 of the UPDF Act but are instead provided for in other legislation. 5, whether it is constitutional for persons subject to military law to be tried in the court-martial for offenses outside the UPDF Act, herein called civil offenses. 6, whether it is constitutional for civilians to be tried by the court-martial as principal for offenses under sections 1191H of the UPDF Act. Yet all those also exist in the civilian offenses. Right Honorable Speaker, the minority has found it necessary to briefly highlight the decision of the Supreme Court in each of the questions, as this will be extremely important. First, in refreshing the memory of the members. Then secondly, and most importantly, guiding the members to properly direct their minds during the debate on the principles and justification of the bill. On the first issue, number 1, whether court-martials are courts established under the Constitution or are mere tribunals. In answering this question, Right Honorable Speaker, which answer was agreeable to the rest of the panel, Honorable the Chief Justice Alphonse C. Owindolo wrote on page 44, paragraph 15 as follows: I would therefore hold the General Court-Martial is not merely a complementary court to civil courts. It is established as a court which is, however, seized with specialized jurisdiction. The take-home from this answer is therefore twofold. 1 is that the Supreme Court recognized the existence of court-martial as a creature of law. And secondly, but most importantly, its special status, implying it is meant for specialized cases only. I now quote the learned Attorney General of Uganda in a letter which I also beg to lay, I believe is part of the documents laid, written on the 3rd February 2025, addressed to the Honorable Minister of Defense, addressed to the following: Honorable Minister of Defense, the Chief of Defense Forces, the Chief of Joint Staff, and Director of Public Prosecutions, in paragraph 2 on page 2 and paragraph 9 on page 3, reproduced below. This, I quote what the Attorney General wrote. Section 197, now Section 195 of the UPDF Act, which establishes the General Court-Martial, is duly established under the law as a competent court, is constitutional. The Attorney General said, our understanding of the above declaration is that the General Court-Martial is duly established under the law and its existence is consistent with the Constitution. However, it must be clothed with the following attributes. A, members of the General Court-Martial must be persons with requisite legal qualifications. B, the members of the General Court-Martial should be independent of the command and have security of tenure. C, there should be adequate time and facilitation in the preparation of defense by an accused person, as well as a right of an accused person to due process and an appeal in capital offenses. D, the convening authority must lie with the General Court-Martial, which guarantees institutional independence from the authority prosecuting the case. This is what the Attorney General advised, and it will help us when we come to closes. It is Attorney General further writes, sections 2, 179, 1191 H and G, now respectively 177, 10X, 1171H, and G of the UPDF Act are unconstitutional since they confer blanket jurisdiction on court-martials to try civilians. Our understanding, this is what the Attorney General wrote, our understanding, the understanding of the Attorney General of this declaration 7, 8, and 9 by the court is that civilians cannot be tried in military courts. Our understanding of this declaration 7, 8, and 9 by the court is that civilians cannot be tried by military courts. I quote from the Attorney General. The minority recognizes the mandate of the Office of the Attorney General under Article 119(3) and 4 of the Constitution of the Republic of Uganda, to wit, shall be the principal legal advisor of government and to give legal advice and legal services to government on any subject. It may be recalled, Right Honorable Speaker, that in both the original constitutional petition, number 45 of 2016, Honorable Michael A. Kabaziguruka versus the Attorney General in the Constitutional Court, and in the Constitutional Appeal, number 2 of 2021, the Attorney General versus Honorable Michael K. The Attorney General diligently and professionally offered legal services representation in court and lost all the arguments except the legality of existence and creation of the court-martial. However, how then does the executive and even parliament expect the same learned Attorney General to again go back to the Constitutional Court and Supreme Court to defend the same issues which he argued and lost? It must be very burdensome, tiresome, hopeless, and frustrating to be a lawyer to the government in such scenarios. Sympathies to the learned Attorney General, Honorable Kiwanuka, and the team of learned friends in the chambers of the Attorney General who prosecuted the case. Can they even dare face the same court again on the same issues already decided by court? Finding. And I must say, on a lighter note, Madam Speaker, a former Attorney General William, Senior Counsel William Biarohanga, I'm reliably informed, asked to be excused from executing role of Attorney General. Then another Deputy Attorney General who was with us here, Honorable Mwesiga Rukutana, immediately he left this role. He had the energy to marry even a young wife. So it is really burdensome to be an Attorney General.
Honorable Duru, you're going personal. Please.
I withdraw.
She has nothing. I mean, what's wrong with marrying a wife?
Finding. Huh? I withdraw, Madam Speaker. Finding. The minority, therefore, finds that there is no legal basis to provide for trial of civilians in the military court as decided by the two highest courts of Uganda, Constitutional Court and the Supreme Court. The minority further finds that there is no political, ideological, and security narration to justify enactment to provide for trial of non-military offenses in the court-martial, and therefore is shallow, unreasonable, and unconstitutional. Court-martials, as found by the Supreme Court, are established legally, hence there is no need to re-establish it. Court-martials, as found by the Supreme Court, and this is what I want members to pay attention to, are already established legally, hence there is no need to re-establish it. The question of restructuring of the court-martial is necessary, but as shall be later pointed out, not possible through provisions of the proposed bill. Subordination of the court-martial. That's the next point of dissent. The Honorable the Chief Justice, Alphonse C. Owindolo, in his judgment, found as quoted below. Additionally, I open the quote, additionally, as already noted, the General Court-Martial and other military courts are all subordinate courts. See the case of Attorney General versus Uganda Law Society, Constitutional Appeal, number 1 of 2006. However, I do not agree with Mulenga, Justice of the Supreme Court's finding, where he held that the General Court-Martial is subordinate, but not lower than the High Court. According to the Black Laws Dictionary, Brian A. Garner, 8th edition, subordinate means placement in or belonging to a lower rank, class or position, or subject to another's authority or control. Assigning the ordinary English meaning to the word subordinate, all court-martials are subordinate courts created under Article 129, 1, sub-article D, and can only have jurisdiction that is lower than the High Court. Saying that it is subordinate but not lower than the High Court is contradictory and has potential to create an absurdity when it comes to hearing of capital offences. If Parliament desires to grant them jurisdiction to handle capital offences, then it would need to do so in line with the Constitution. The minority observes, Madam Speaker, that Article 129 of the Constitution of the Republic of Uganda provides for the courts of judicature as stated in the judgment. Article 129(1), the judicial power of Uganda shall be exercised by the courts of judicature, which shall consist of A, the Supreme Court of Uganda, B, the Court of Appeal of Uganda, C, the High Court of Uganda, and D, which is underlined, such subordinate courts as Parliament may by law establish, including the Cadi's Court for marriage, divorce, inheritance of property, guardianship, as may be prescribed by Parliament. Article 129 of the Constitution is on the jurisdiction of the High Court and states as follows, and we can read together. 1. The High Court shall, subject to the provisions of this Constitution, have unlimited original jurisdiction on all matters and such appellant and other jurisdictions as may be conferred on by this Constitution or other law. In light of the judgment of the Supreme Court, Madam Speaker, any court created by Parliament is inherently subordinate to the High Court. Any court created by this Parliament, whether we go ahead and create or not, is inherently by this provision of the Constitution subordinate. We cannot create a court equal or higher. For any court to be created with either the same or higher jurisdiction to the High Court, it has to be directly created in the Constitution under Article 129, sub-article 1, and listed either in, you can reflect, in clause 1C with the High Court, meaning at the same level, or immediately before clause 1D to exclude it from the subordination. The minority also observes further that conferring unlimited jurisdiction on courts created under Article 129, other courts other than the three courts of record. The minority also observes further that conferring unlimited jurisdiction on courts created under Article 129D, which we are about to do, of the Constitution is equivalent to amending Article 139, sub-article 1 of the Constitution, to the extent of creating exceptions limiting the already unlimited original jurisdiction conferred by the Constitution of the High Court. I can repeat that. The minority observes further that conferring unlimited original jurisdiction on courts created under Article 129D, such as the court-martial of the Constitution, is equivalent to amending by infection Article 139(1) of the Constitution to the extent of creating exceptions limiting the already unlimited original jurisdiction conferred by the Constitution on the High Court. Is it therefore allowed to amend the Constitution through an amendment of an Act of Parliament? The obvious answer is no. The Constitution can only be amended in conformity to Chapter 18, Articles 259 to 263 of the Constitution of the Republic of Uganda. The minority submits that the UPDF Amendment Bill 2025 is not a bill for an act to amend the Constitution, and therefore cannot attempt by trickery or any other means, including fraud, purport to amend Article 139 of the Constitution of the Republic of Uganda. Right Honourable Speaker, the advisory order recommendations of the Supreme Court are stated in paragraph 10 on page 199, bullet E of the judgment of the Honourable, the Chief Justice Alphonse C. Owindol as follows. E, amend the Constitution, and pay attention, this is what the Chief Justice ordered or recommended. Amend the Constitution to establish superior courts within the military court system under Article 129, and clothe those courts created by amendment of the Constitution with the requisite jurisdiction and guarantee of independence and impartiality to try specific military offenses under existing laws committed by military personnel. F, the Chief Justice advised, provide in the UPDF Act for the High Court, which is already created and in existence, to sit as a court-martial with power to try all criminal capital offenses within the High Court's jurisdiction, and those unique to the military that attract maximum of life and death sentences. Grant the Chief Justice powers to assign judges to the military courts. A select number of military personnel can therefore act as assessors. Appeals to the court-martial appeals court would follow the same format, with Court of Appeal sitting as such. Magistrates' courts would assume the jurisdictions all over other offenses of a subordinate court. G, the Chief Justice says, make provisions in the UPDF Act for trials of civilian in the military courts to be only under limited circumstances and only after the state concretely demonstrates to the court by verifiable facts and by objective and serious reasons the need and justifications for recourse to the military courts. This must only apply where, in relation to the specific class or category of persons, offenses in question, ordinary courts are not in position to undertake. This is the quote of the Chief Justice upon which this bill has been brought. The understanding of the minority on these advisory orders E to F and G above is that they are premised on the fact that all trials of both civilians and military personnel who commit non-service stroke military offenses must be before civilian courts. In other words, the current civilian courts, Magistrates Court, High Court, Court of Appeal, and Supreme Court are all competent by all standards required under Article 28 and 44 of the Constitution of the Republic of Uganda to try any offense in the law books of Uganda. A question was put to the learned Attorney General on whether his trust, confidence, and belief, a question was put to the Attorney General on where his trust, confidence, and belief would lie in delivery of justice on the offenses proposed in the bill. Were those trials to take place premised on the same facts before either the civilian courts or the court-martial? So we have two sets of same offenses. Which of the two courts would the Attorney General trust? The learned Attorney General answered that both courts can and will deliver justice. The understanding of the minority on this answer is that the learned Attorney General confirmed that civilian courts in existence right now is capable of conducting any trial of criminal nature in Uganda without need to waste time and resources on the court-martial, which has unconstitutional structure. The structure, not the court-martial. The court-martial is constitutional, but its structure has unconstitutional structure, incapable of delivering a free, fair, and impartial justice to any accused person. Even, Madam Speaker, even if this answer is denied, the question to the government and the mover of the bill is the government of NRM in power for 39 years and who virtually recruited and appointed all the cadres, the investigators, the police, the prosecutors, office of the DPP, the arbitrators, the judicial officers? If we check on the record of the current structure of police, leadership, and the rest, all of them have been recruited by this government. Are they therefore justified to complain on the incompetence, the weakness in the judicial system? The question is, the NRM government in power for 39 years and who recruited and appointed all the cadres in the justice system, the police, prosecutors, and the arbitrators, the judicial officers, are they justified to complain on the incompetence, weakness in the civil courts to handle any case in Uganda? If the minority was granted more time, Right Honorable Speaker, it would have produced on record all cases of murder, aggravated robberies, terrorism proposed in the bill against accused persons, including military personnel, which has been successfully prosecuted in the civilian court. By the time of writing this report, Madam Speaker, I had not known that yesterday the High Court convicted a former soldier, a militant, of an offense. That further demonstrates and strengthens my argument that actually the civilian courts right now can convict, try and convict, murder, aggravated robbery, etc. The minority invites the attention of members, especially those familiar with court papers, to reflect on the proposal of the Chief Justice, which captures the spirit of the advisory order by the Chief Justice as follows. I have put a heading there just to illustrate when we come to the amendment. All the headings of courts in Uganda would be written the Republic of Uganda. In the High Court of Uganda, it could be in Kampala, the example, and in bracket, we put the provision for court-martial stroke military division. That is what the learned Chief Justice had advised. Finding, the minority finds that the proposals in the Uganda People's Defense Forces Amendment, Bill 2025, purporting to recreate the court-martial with unlimited original jurisdiction is unconstitutional, as it inadvertently amends Article 139 of the Constitution of Uganda without following the procedure of amendment provided under Chapter 18 of the same Constitution. The minority further finds that it is administratively viable to provide for a specialized court within the civilian courts for purpose of trial of criminal offenses committed by the military person. The next point of the dissent is on limited or exceptional circumstances, as has been said. Madam Speaker, the minority recognizes the discussion in the judgment on the limited circumstances of trials of civilians and or military persons in the court-martial in Uganda. In the judgment, the minority understands that these circumstances appear to be strictly in reference to a situation where, and we can pay attention, one, the Constitution is not in force, similar to the military rule during Idi Amin's regime. That is the first condition for trial of civilians in the military court. There must not be constitution in force. Two, courts of law have no capacity to try the offenses. For example, there are shortages of competent judicial officers. Three, soldiers and civilians are on duty or deployed in a foreign land where there is no possibility of returning them for trial in Uganda, and there is no other court in that country to try the accused. We all know where our army, the UPDF, are deployed, so the court martials can try them there in case that country does not have a law or the situation of the war in that country. That is the understanding of the minority. The scenario of Karamoja, which was presented in the committee as a success story of the court martials, was unjustified. It was claimed that judicial officers had feared to be deployed in Karamoja to hear cases because of insecurity. These are the questions. Were other courts in the neighboring districts also unavailable to try those cases? Did the same government demonstrate to Ugandans that courts in Karamoja were fully functional when Colonel retired Dr. Kiza Besigye was flown to Moroto and charged in the civilian courts? Who is mandated to ensure law and order in Uganda? And why not deal with the root causes of it all, which is the security of the judicial officers, rather than recourse to the courts martial? Madam Speaker, were the trials free and fair in Karamoja? The presumption of innocence, the charge sheets, were they read through them? Did they take proper plea? Did they give evidence as per the Evidence Act? Was there a ruling on the prima facie case? Was there a defense? Were there the convictions? Did they allow them to plead to mitigate? And what was the sentencing guideline? In the opinion of the minority, it is foolish to legislate to provide for unconstitutional situations, like providing for scenarios where the constitution laws are not enforced. All I am saying, Parliament cannot sit and legislate for a situation where the constitution is not. It would be foolish of us to do that. And as such, to make...
At least not everybody is foolish.
No, I just said it is. I didn't accuse anybody. Right, Honorable Speaker, to make all Ugandans liable for trial in the military justice system. First, all Ugandans Madam Speaker, to make all Ugandans liable for trial in the military justice system, first of criminal offences committed by the military person. Point of the dissent is on limited or exceptional circumstances. Madam Speaker, the minority recognizes the discussion, judgment on the limited circumstances of trials of civilian or military persons in the court-martial in Uganda. In the judgment, the minority stands that these circumstances appear to be strictly in reference to where, and we can pay attention. One, the Constitution is not similar to the military rule during Idi Amin's regime. First condition for trial of civilians in the military court, there must not be constitutional. Two, courts of law have no capacity to try the offense. For example, there are shortages of competent judicial officers. Three, soldiers and civilians are duty or deployed in a foreign land where there is no possibility of return for trial in Uganda, and there is no other court in that country to try the accused. We all know where our army, the UPDF, are. So the court martials can try them there in case that country does all the situation of the war in that country. That is the understanding of the minority. Scenario of Karamoja, which was presented in the committee as a success story of the court-martials, was unjustified. It was clear that judicial officers had feared to be deployed in Karamoja to years because of insecurity. These are the questions. Were other courts in the districts also unavailable to try those cases? Did the same government demonstrate to Uganda courts in Karamoja were fully functional when Colonel retired Dr. Kizza Besigye was flown Moroto and charged in the civilian courts? Who is mandated to ensure an order in Uganda, and why not deal with the root causes of it all, which is the security judicial officers, rather than recourse to the courts-martial? Madam, were the trials free and fair in Karamoja? The presumption of innocence, were they read to them? Did they take proper plea? Did they give evidence as per the evidence? Was there a ruling on the prima facie case? Was there a defense? Were there actions? Did they allow them to plead to mitigate? And what was the sentencing guideline? In the opinion of them, it is foolish to legislate to provide for
n'ekitundu ezemisana.